tell me and this committee that you consider private investigators going into sexual habits, drinking habits, domestic problems, and personal social activities as a proper subject for investigation during the course of a political campaign?
Senator, I know of my own knowledge of incumbents in office who are not discharging their obligation to their constituents because of their drinking habits. And it distresses me very much. And there's a kind of an unwritten law in the media that is not discussed. And so the constituents at home have no way of knowing that you can go over here in the gallery and watch a member totter onto the floor in a condition which of at least partial inebriation, which would preclude him from making any sort of a sober judgment on the issues that confront this country. Now, I think that is important for the American people to know, and if the only way that it can be brought out is through his opponent in a political campaign, then I think that opponent has an affirmative obligation to bring that forward.
In the Senate of the United States, a resolution to establish a select committee of the Senate to conduct an investigation and study of the extent, if any, to which illegal, improper, or unethical activities were engaged in by any persons, acting individually or in combination with others, in the presidential election of 1972, or any campaign, canvass, or other activity related to it.
From Washington, NPAC brings you gavel-to-gavel videotape coverage of today's hearings by the Senate Select Committee on Presidential Campaign Activities. Here is NPAC senior correspondent Robert McNeil.
Good evening. Today was the day that John Ehrlichman didn't complete his testimony, putting the Select Committee even further behind schedule. And today was the day Ehrlichman suggested to the committee that Anthony Ulazowitz, the White House private eye, who probed the personal lives of potential Democratic candidates, performed a legitimate service, helping the electorate know of any defects in the character of candidates. Today also, Ehrlichman detailed his investigation of the Watergate situation in April. The former White House domestic aide says he concluded that Jeb Magruder participated in the break-in plans, but that presidential lawyer Herbert Calmbach, who furnished funds to the Watergate defendants, acted in good faith. And Ehrlichman concluded John Dean didn't really tell the president the whole story at their meeting in late March, despite Dean's testimony to the contrary. The questions raised a few days ago about national security haven't been resolved, and once again the committee ends a week work with more new questions than answers.
As you will see, it was a different day for John Ehrlichman today. He was finally asked some detailed, relevant questions about Watergate and his possible involvement in its cover-up. Jack Murphy of the Georgetown University Law Center here in Washington is here with us now. Jack, what specific points would you advise people to watch for tonight?
Jim, we got away from trivia and red herrings today. I'd suggest to your viewers that they pay particular attention to Senator Gurney, his examination with pinpoint questioning of the critical meetings of March 21st and 22nd of this year between Mrs. Haldeman, Ehrlichman, Dean, and the President. Senator Weicker will follow that with fascinating detail about the meeting between Mr. Haldeman, Mr. Ehrlichman, and Mr. Helms and General Walters back in June of 1972. And in addition, he will give you some sense of the way the White House viewed Acting Director Pat Gray as late as March of this year, prior to Gray's departure from the post in April 27th, I believe it was, of 73. Finally, Senator Ervin will fascinate, I think, your audience with his notions of the possible presidential responsibility for interference with grand jury deliberations as to who was responsible for the break-in.
Okay, thank you. Jack Murphy will be back at the close of tonight's broadcast to discuss all this in more detail. He'll be joined at that time by Clark Molinoff, Pulitzer Prize-winning investigative reporter of the Des Moines Register-Tribune, syndicated columnist, and former special consultant to President Nixon.
As Professor Murphy indicated, the former aide to the president was pressed on several fronts today. To help you watch those, here is NPAC's hour-by-hour viewing guide to the hearings. In the first hour, John Ehrlichman begins to detail his Watergate investigation for the White House from notes he gave the committee. He says he was told it was Jeb Magruder who was pushing Gordon Liddy for more intelligence information. He says in April of this year he learned that Howard Hunt had supplied a Florida printer for 3 of Donald Segretti's dirty tricks agents. In hour number 2, Ehrlichman says that at one point John Dean wanted the president to negotiate blanket immunity for all White House staffers. And Ehrlichman says when he talked to Gordon Strachan, There was not a scintilla of a mention of shredding documents from Mr. Haldeman's files. Also in that hour, Senator Gurney questions Ehrlichman about his meetings with Dean. In hour number 3, in answering Senator Weiker's questions about White House horrors, Ehrlichman finds John Mitchell's recollection hazy, as he put it. Asked about CIA involvement in the investigation, Ehrlichman says the president wanted him to deal with General Walters instead of CIA Chief Helms. In the final hour, Senator Weiker asks about conversations concerning the troubles Patrick Gray was having getting confirmed as FBI director. At one point, Ehrlichman told Dean to let Gray hang there. And in responding to Senator Ervin's questions about special treatment for Maurice Stans, Ehrlichman said he called the Justice Department on a request from the president. As a result, Stans avoided a grand jury appearance. Now, Senator Ervin is about to start the 4th day of John Ehrlichman's testimony.
I didn't see your program last night, but I told it and appreciate the very gracious things you said about me on here. I meant them. Well, I appreciate it. I'm sorry I didn't see you. I'll let you have it too. I didn't see you.
Senator Ervin is congratulating Senator Baker on an appearance last night on the Jack Parr show, in which apparently Senator Baker said very complimentary things about the chairman.
Thank you very much. Mr. Ehrlichman, when we recessed yesterday, we were discussing your interviews as part of the inquiry you had made in behalf of the President. And in response to one of my questions, you indicated that you had discussed or talked with Mr. O'Brien, Mr. Calmbach, Mr. Dean, Mr. Mitchell, and again with Mr. Strawn. And you've indicated that you had maintained interview notes.
Of some of those, Senator, and I neglected to say I also talked with Mr. Krogh because of something that came up in the course of these interviews that I wanted to inquire about, so he would be an additional individual that I talked to.
We have no notes on Mr. Calmbach, Mr. Dean, Mr. Mitchell, or Mr. Strawn. Is there any reason for this?
You should have. There are notes for Strawn and Dean. There are no notes for my talk with either, for my talk with Mr. Calmbach. We did turn over to the committee staff the transcript of my interview with Mr. Mitchell, which is a very, very poor one. It's not very helpful. It's very sketchy.
Dr. Dash, do we have the copies of the Calmbach, Dean, Mitchell, and Strawn?
There are no Calmbach notes, Senator. There are Dean and Strawn notes. The notes that I have here are O'Brien, Dean, Colson, Magruder, and Strawn.
Senator, in a way, whatever you have what we got. In other words, that was intact, delivered to us in that form, and we have no other notes.
Then we have here, Mr. Ehrlichman, one Strawn, and you had 2 Strawn meetings.
There are only notes for one.
We have a Reasoner meeting.
No, I think that that is actually the... Oh, that's the Dean meeting. JD is up in the corner of it. That's the Dean meeting on April 13 at 3 p.m.
Then we have an O'Brien meeting.
Yes.
And Colson and Shapiro.
Right. No, you have the transcription of 2 tapes, Mitchell and Magruder, that are both very hard to read and hard to understand because the tapes are hard to understand. You also have the tapes themselves, and therefore whatever they're worth. I don't think you can make much from them.
I received these notes early this morning, Mr. Ehrlichman, and I must confess that I find it very difficult to understand your hieroglyphics here.
Right.
And so, if I may ask you, whenever the initial H appears, is that for Mr. Haldeman?
Not necessarily. You'd have to take it in the context, Senator. That could also be Hunt in some cases here, although I used a double H for Hunt on occasion.
JNM is John Mitchell, isn't it?
Yes, sir.
And JSM is Magruder.
Yes.
L or LD or LID is Liddy?
Well, LID is certainly Liddy, and I don't recall the. Yes, I've used L also for Liddy in the Magruder notes.
And K or EK for Krogh?
I believe so. Yes.
And CC for Colson?
Yes.
Now there's a Greek symbol, the symbol pi. Who is that, sir?
That's the president.
That's the President of the
Yes,
United
sir.
States. If we may we begin with your meeting with Mr. O'Brien
Yes, sir.
at San Clemente?
Right.
Please tell us what transpired in your
All right,
interview.
sir. The circumstances of this meeting were that Mr. O'Brien indicated that he had some information that he felt the president should have. He called and asked for an appointment with Mr. Haldeman. In view of the fact that 4 or 5 days previously the president had asked me to get into this, he was referred to me. We met in my office at San Clemente, and he began to tell me about what he believed would be Mr. Magruder's testimony. In the upper right corner you will see that he told me that the purpose of his being on the coast was to see Herb Calmbach in connection with some of the civil litigation which Mr. O'Brien was handling for the committee to re-elect.
This happened on April the 5th of 73.
April 5 at 10 in the morning, yes, sir. He said that there had been 4 meetings which led up to the Watergate break-in, and you will see that the meetings referred to by numbers with circles around them. We start with number 1, which is actually the 4th one that he described to me, which was a meeting between Liddy, Dean, and Mitchell in the Attorney General's office in November. He said that Mr. Mitchell...
November of what year, sir?
That would have been 1971. That was a meeting which Mr. Mitchell apparently did not recall, which was held for the purpose of Mr. Dean introducing Liddy to Mitchell. The second meeting appears in the date notebooks of various parties, and that was a meeting between Dean, Liddy, and Magruder for the purpose of introducing Liddy to Magruder, and that was held on the 27th of January of 1972. There was a subsequent meeting on February 4 involving Dean, Liddy, Magruder, and Mitchell. He said that the third meeting was, quote, canceled. That is to say, the parties agreed that it would be described as a meeting that had been canceled. And then he refers later on to the construction of that story, or that version. He said that John Dean, and this, bear in mind now, is hearsay twice removed. This is Magruder telling O'Brien, telling me. He said that Magruder said that Dean kept Haldeman advised by memo of all of these meetings. Actually, there were 4 meetings. And then he starts through, again, the first meeting in November, which I've described. He said there was actually a third meeting, which was not any of these that I have heretofore described, where $1 million budget was proposed by Liddy. Everyone at the meeting agreed that that budget would not be adopted.
Did he say for what reason?
I didn't ask him. I don't believe at that point.
Was it because of the price tag alone?
I don't know, Senator, from this conversation. He didn't say. He said that between meetings 3 and 4, Mr. Colson phoned twice to Jeb Magruder. Now, in parenthesis, I have only according to Jeb, which indicated what Mr. O'Brien told me, that this was the only person he'd ever heard this from was Magruder, urging that this program go forward. Now, I have the notation not price, and I don't know to what that refers any longer. That doesn't jog my recollection at all. He said that Liddy had a commitment from Krogh, that Hunt had a commitment from Colson, and these commitments, I took it, related to executive clemency. That was the context in which that comment was made.
Liddy had a commitment from Crow
Yes, sir.
that he could receive executive clemency?
That was what Mr. O'Brien said that Mr. Magruder had told him.
And Mr. Hunt said that he had a commitment from Mr. Chuck Colson?
No, and I'm not saying that Hunt said that. Bear in mind, this is Magruder speaking to O'Brien now. Now, because of this assertion, I did contact Krogh later on to determine when he had had contacts with Liddy and to try and either verify this or set it aside. And parenthetically, circumstances indicated that he had had no contact, either direct or indirect, with Liddy, and so it was not borne out by anything that I could find collaterally in the time in which I worked. He said that at the fourth meeting, Dean arrived late. Magruder, Dean, Liddy, and Mitchell attended the meeting. There was an intelligence budget of $200,000 to $250,000. Dean said to Liddy that he, Dean, would have nothing further to do with this. I asked him about charts, and he said that charts did exist. And the reason I asked him, of course, is that there was something in the press at this time about the existence of a set of charts. He said that the code name gemstone was used, that term was not translated into what it really stood for at this meeting. The parties, he said, apparently didn't know, or that's what Magruder told him. I said, was bugging involved? And he said, yes, bugging was one of the methods involved. It also involved counter activities at the convention. Then,
did you know what the $1 million budget involved?
He didn't tell me. This characterization at the bottom of the first page referred, so far as I can recall, to the $200,000 to $250,000 budget. He told me that there was a second intelligence operation at the committee to re-elect which was not involved in this series of 4 meetings. This involved a cab driver who volunteered at the Muskie headquarters. He had been recruited by a friend of Ken Reitz, who was a former FBI man in Tennessee. And he went into the Muskie headquarters and volunteered and became Senator Muskie's chauffeur and a friend of the family, and went to the Muskie's house for dinner, and soon began carrying all of the senator's mail back and forth.
And he photographed all the mail?
Yeah, he photographed all of the mail.
And who is this friend of Ken Reitz?
The FBI man? I don't know. I don't have his name, but apparently your staff should, because when the Senate staff was looking for someone for this committee's staff, he was approached. And so it shouldn't be too hard to find out who that was. He declined the employment, apparently. One of the pieces of mail apparently was printed in Evans and Novak, and so everybody in the Muskie organization was questioned about it except the chauffeur. And the chauffeur was a volunteer. He was paid nothing. Eventually, he was transferred from Reitz to Howard Hunt for purposes of management and reporting. Then I have a notation that Reitz became worried at some point about cash funds, and I believe that refers back to this business of the transfer. In other words, Reitz didn't like what he saw about cash in the organization, and he wanted out, and at that point he discontinued any connection with this kind of activity, and Howard Hunt took it over. I have a note, Magruder was pushing, and I think what that refers to is a statement that Magruder was pushing generally for intelligence information. He told me that Magruder told him that there had been an entry into the Democratic headquarters in May and a bug had been planted, that he was satisfied that neither Dean nor Mitchell had knowledge of either the May or June break-in, but that Mr. Magruder did. Then he mentioned that he had been no, I think this is Mr. O'Brien speaking for himself. He was advising caution with regard to John Dean's objectivity in the advice that he might be giving the President in this matter.
What is Hofgren?
Hofgren is Daniel Hofgren, and that name relates to the note that I will come to farther down on the page. Mr. O'Brien said that Magruder reaches Strawn, Haldeman, Colson, and the President in his story. I said, how does Magruder reach the President? And he said, in this circumstance. Magruder fired Gordon Liddy, he will say. Gordon Liddy went to Gordon Strawn, and Gordon Strawn came to Magruder and said, move him back. That is, this is Strawn talking to Magruder, saying, move Liddy back. The President wants this project to go on. I said, is there any other way that this reaches the President? And he said, not that I know of. Now, he said, according to Mr. Hofgren, Mr. Magruder's wife was indicating to their friends, apparently, that there was a possibility that Mr. Magruder would be indicted and that he was planning to leave the government. And that's the reference to Hofgren at the top of the page. Now, Mr. O'Brien said that neither Magruder nor Mitchell, in his, O'Brien's opinion, were inevitably hung in this case by the evidence as he understood it to that point. He said, frankly, John Dean is the key problem. Mr. O'Brien was concerned about the post-Watergate situation and about the handling of money. And then he began telling me about this money situation which concerned him. He told me about Mr. Rivers, Mr. Calmbach's man who delivered $25,000 in cash to Attorney Bittman by leaving it in a phone booth. And I said, what became of the money? And he said, I believe it was deposited to their firm account. He said there has been obstruction of justice, in his opinion. I asked him to define what he meant by that. He said that a defendant in a criminal case is also a witness. And the purpose of giving money to such a defendant becomes very important. It's okay if one gives them attorney's fees and defense funds, or possibly even subsistence, but not consideration to not talk. In other words, the quid pro quo of silence. Then he said money flowed to Howard Hunt, in turn to Howard Hunt's wife, and then in turn $19,000 to Mr. McCord, which in turn went to McCord's attorney. And this was an example that he was citing to me. He said Tuesday of this week, meaning the week of the 5th, that McCord was going to present a letter to the court which implicated Attorney Parkinson. He quoted McCord as saying, this letter is a lie, but I am going to get these bastards. He felt that having said that to the attorneys in the case, that comment was privileged. But apparently McCord got cold feet. He stood up to deliver the letter against Parkinson in court, but then he sat down without doing so. Then he characterizes Mr. McCord, Mr. O'Brien does, in the adjectives that you see there in the exhibit. He said later, and I don't know what later, oh, I know what later refers to. I was interrupted in this meeting and went out, I believe, to take a phone call and came back. He said that Mrs. Hunt has written a memo which names Bittman and Parkinson as involved in the money business. There's a memo from Parkinson to Dean to LaRue. The memo went to LaRue because LaRue was responsible for obtaining the funds for this purpose. Just before Howard Hunt was sentenced, which would have been in March, as I recall, although it doesn't say so here, Bittman phoned O'Brien, who in turn passed a message to Dean, Mitchell, and LaRue, that Hunt was making a demand for $70,000. Then he said, in his opinion, the attorney-client privilege will not cover meetings he was in or any conspiracy that he was in, and that refers to John Dean. And then he mentioned to me that Dean's attorney is Mr. Hogan, and the Dean is represented and that he is actively counseling with an attorney. He said that 2 blocks of money were delivered by Mr. Mitchell, I take it not personally, but by the campaign, to Mr. Haldeman.
How many dollars?
I don't know. I don't know, and I don't think he knew. I believe I asked him.
Was this in cash?
I don't know that either. He just said that because I was pressing him for any White House involvement, and all through these interviews, Senator, that was the kind of the key question all the way through. He said the night of Watergate break-in, Sloan and Stans took cash home, amounting to about $81,000, which they returned the next day. This was given to LaRue on advice of Mardian, and this money was used for subsistence for the defendants. He said Mr. LaRue has $100,000 now, $81,000 of which he has held since that time, for the past 11 months. Sloan said to O'Brien that $1 to $2 million in cash had come in. Stans reported that it was about $1.7 million, which included $275,000 that had gone to Calmbach and a $350,000 sum which had gone to the White House. He said, Mr. O'Brien said that one sheet of paper exists with an accounting of this $1.7 million on it, and 3 people know where that accounting is.
Who are the 3 people?
Well, I'll come to that later on in the account. I think I better take this seriatim, if you don't mind, to explain the hieroglyphics as we go along. He said that as far as his reputation was concerned, Mr. Stans was, quote, done, unquote, but he, O'Brien, did not foresee that Mr. Stans would be indicted. He is not guilty of any perjury. He had been very foxy in the statements that he had made, that if he could spend a week with Mr. Calmbach and could get their accounts straightened out, he didn't foresee that there would be any liability in Mr. Stans. Then we talked about the civil suits. There were 2, the Democratic suit and the Common Cause suit. He felt that if the committee to re-elect would only file with the Congress an accounting of all contributions, that the Common Cause lawsuit could be mooted. It would take somewhere between 2 weeks and 6 months to get those accounts in shape. He didn't know just how long it would take. He said that Mr. Stans was extremely opposed to doing this because this would break faith with the contributors who had contributed anonymously. He said, if we do not do this, I'm satisfied we're going to lose the case. In the Democratic National Committee suit, settlement negotiations were underway because Larry O'Brien was now on the payroll of Dwayne Andreas. Mr. Andreas held his future. Mr. O'Brien, as long as the countersuits existed, couldn't get credit. He told me he couldn't buy a house. Robert Strauss wants to settle the case. Mr. Mitchell met with Strauss the previous day. The number that was being kicked around was a $500,000 settlement, and he said there's $5 million available in the committee to re-elect Treasury to make that settlement. Howard Hunt was a prime Howard Hunt was a prime contact for Segretti, according to Mr. O'Brien. And I don't know what his source for this information is. I think we've gone out of the Magruder part of the source business now. That Hunt supplied a Florida printer to 3 key Segretti men, one a man named Norton from Los Angeles, and a man from Tampa, and another man from Florida whose names he didn't know. And these 3 people performed dirty tricks.
What were the dirty tricks?
Well, the only one that I have a note of is the note generator of Canuck letter. And presumably he meant by that either Segretti or one of these 3 people were the generator of that letter. And what his source is for that, I do not know. I asked him about Dwight Chapin's involvement in this. He said, well, Chapin will take a bath, by which he meant his reputation or his good repute will be affected. He said someone is working newsmen for more favorable stories. And his source of information on that was a reporter named Lasky, who told him that this was going on. He said that Chapin had had a lot of Segretti contact. He said Segretti had an immediate worry, which was that he had received these payments of cash that you see here in the exhibit, totaling $40,000. By April 15th, he was going to have to pay his income tax. He needed guidance from somebody as to how to show that money as income or not, and he lacked money to pay his taxes. He said he's got the problem of how one describes his business and how to deduct a business expense under those circumstances. He said that Mr. Segretti had kept a very complete diary in which he had cataloged all of his expenses. He then told me about Mr. Fensterwald, who was an attorney representing McCord. He said that Mr. Alch wanted out as McCord's attorney. McCord had done some things which Alch did not approve of, such as phoning the embassies at Chile and Israel with the thought that they were tapped so that he could be dismissed from the government's action against him. McCord also had sent an unsigned letter to Jack Caulfield, which Mr. O'Brien described as sick, which related to the CIA and Mr. Helms and so forth. He said that Caulfield had taken the letter to Mr. Dean. Caulfield had seen McCord 3 times. I asked him whether Caulfield had made any offers to McCord. He said he didn't know. He thought perhaps he had offered clemency, but he thought also that this would be susceptible of proof because McCord very well may have taped him, so to speak.
I hate to interrupt the proceedings, but there's a vote on in the Senate, and the members of the committee have to go over and perform their senatorial duties.
The senators are again working on amendments to the Campaign Reform Act. While they're on the Senate floor, we'll take a break. Public television's coverage of the Senate hearings will continue after a pause for station identification.
From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
Senator Baker brought the committee back to order and turned the questioning back to Senator Inouye.
The chairman has been temporarily detained, and he asked me to recommence the hearings and to thus permit Senator Inouye to continue with his examination.
Mr. Chairman, I notice that my time has expired, but I wanted the committee to know that my line of questioning was a very simple one. I just wanted the committee to be aware of the symbols in your notes and to better understand your interview notes.
Senator, on that, there's a kind of a personal shorthand that runs through there of a few Greek letters, which I'll be glad to give a Rosetta Stone to the staff on if they need it.
And will you provide us with your transcript of the meeting with Mr. Mitchell also?
I have done so, I believe.
Again, what I have given to you, in a way, is everything that we received. And
Did you give him the cassette and the transcript of the cassette, Counsel?
Oh, we have the tape of the Mitchell meeting? Yes. That's right. We have the tape of the Mitchell meeting. I'm talking about the notes.
No, the thing I referred to in answering the senator's question was that tape and the transcript of the tape, which is all that I have of that meeting.
I think, Mr. Vice Chairman, that Mr. Strickler and Mr. Hamilton had an exchange whereby the transcription that we had was sent up. Is that right, Mr. Hamilton? That's correct.
Mr. Chairman, now that I better understand the hieroglyphics and the notations and the symbols, I would like to yield the floor. Permit me time to study these notes so that I can ask questions based upon these notes at a later time. So I thank you very much, Mr. Ehrlichman.
Thank you, Senator Inouye. Senator Gurney, I understand, has a few additional questions, but since he hadn't returned to the hearing room yet, I wonder, Senator Weicker, if you're in a position to continue with your examination.
Mr. Vice Chairman, before the Senator begins, if I could just put a concluding note on Senator Inouye's examination, more or less to drop the other shoe. These notes were not included in the President's papers, unlike my other notes, at the President's specific instance, in order that they could be available to the Attorney General and the prosecutors as source material, and of course the committee. They were transmitted first by a phone call to the Attorney General, and then by a conference with the prosecuting attorney, and then by an appearance at the grand jury, during which these were all gone through in great detail.
The report which you presented to the President?
Sir, my report to him was oral.
Was it taped?
I have to assume so. It was given in the Executive Office Building office.
On what day, sir?
On the 14th of April.
Thank you very much, sir.
I note that Senator Gurney has now returned to the committee table, and if it's agreeable, then we'll proceed with interrogation by Senator Gurney instead of Senator Weicker in the regular course.
Thank you, Mr. Chairman. Mr. Ehrlichman, we have touched base once or twice on the Calmbach transactions between him and you. And I'd like to clean up one other point on that. That was the conversation you had with him on April the 19th, telephone conversation. And this was the one that was taped. We have a record of the tape here, of course. Do you have a copy of that, by the way?
I believe I do.
Let's turn to page 5 on that. There was some conversation about his coming over and talking to you. Is this phone conversation, as I understand it, was just prior to the time he was going to appear before the grand jury?
Yes.
Like the day before. And he was here in Washington and talking to you, and he said something about touching base with you before he went down to talk to the grand jury. And you said to him, well, it's all right, but of course they'll ask you about it, and indicated maybe you don't want that information to come out. So I'll start there if you want to. That is, if you want to come over and talk. They'll ask you. Calmbach, will they? And you said yes. And Calmbach said, well, maybe I shouldn't. And you said they'll ask you to whom you've spoken about your testimony, and I would appreciate it if you would say you've talked to me in California, because at that time I was investigating this thing for the president, Calmbach, and not now. Ehrlichman, well, I wouldn't ask you to lie. Calmbach, no, I know. Ehrlichman, but the point is, Calmbach, the testimony was in California. Can you tell the committee what that would be all about? I mean, why would you want him to tell the grand jury that this phone conversation between you and him that day in Washington would better be reported to be in California?
Well, no. I was referring to an interview that I had with Mr. Calmbach in California in connection with this inquiry that I was doing for the president. And by that, I simply did not want Mr. Calmbach to omit in his testimony, if they asked him what contacts he'd had with me, be sure and tell them about that one in California, because I was going to have to tell them about it, and I didn't want him to be caught unawares. That was a meeting which was not held in my office. It was held in his automobile. And I was a little concerned, frankly, that he might for some reason omit to testify to it. I was intending to testify to it. I obviously would have to, as to who I had talked to in the course of this investigation.
Were you concerned about his reporting this particular conversation that we're talking about now?
No, no. Matter of fact, I turned over this transcript to the prosecutors and the grand jury.
How often did you tape conversations on the recording device you had in the office on your telephone?
I didn't hear the first part of your question, Senator.
How often did you use the recording device that you had on your telephone to record conversations?
In routine business, very occasionally, not very often. As I got into this Watergate phase after March 30th, I began more and more to use it with people that I thought were somehow or another involved in the matter, and I used it in connection with the stories that came back to me about the charges that were being leveled against me by Mr. Dean in my calls to Colson and Clausen and Curlie and Clark McGregor, people that I thought might provide me with some supporting evidence for my recollection as to what actually had happened.
Well, that could be understandable, but how about Calmbach? Now, Calmbach was your very good friend, was he not?
Yes, but he was also very knowledgeable in this case, and he had been one of the people that I had interviewed to try and gather information for the president on the money end of this thing. And so I considered him to be a witness, if you please, in the inquiry.
Of course, Calmbach's reaction, as I'm sure you know, is total shock at this recording.
I understand, and that I regret very much, but I had an assignment from the president that I felt I had to carry out. Matter of fact, I did some checking on Mr. Haldeman, who's also my very good friend. I did that because I felt I had to bring to the president whatever information was available in the higher interest.
Are you saying now this is during the period of time that the president had reassigned the business of Watergate to you and from Mr. Dean?
Yes, sir.
Is that correct? Going back to that assignment of investigation of the Watergate to Dean, now I'm not talking about June, July, I'm talking about February of this year. Matter of fact, I think Dean talked to the president on February the 27th, and in that conversation with the president assigned the investigation of Watergate, at least that current phase of it, to Dean. As I recall, he said that he wanted Dean to report directly to him. I think he also said that it was taking up too much of your time and also Haldeman's time. Was that ever discussed with you or with Haldeman, the president's decision to have Dean now become the chief investigator of Watergate, February 27th?
Yes, Senator, except chief investigator, I think, is slightly off the track. The preoccupation at that time, as far as the president was concerned, was not in an investigation of the facts, as nearly as it was to get some one person in the White House who was going to look after a number of existing problems with relation to this whole subject matter. And they were primarily the problems of executive privilege and separation of powers, as he saw it then, not a question of whodunit. And so rather soon after this meeting we had at La Costa, which was at the result, incidentally, the meeting was a result of the president saying who's in charge and what plans are being made and how's the work coming.
And this came at about the time this committee was created,
yes,
is
sir.
that right?
That's
right. The concern about what to do about the investigation of the committee, how to respond to it?
Yes, sir. That was certainly part of it.
Go on.
Coming out of that session, as a result of our report back to him, that the work was largely undone, that a tremendous amount of work was left to be done in terms of developing the administration's position on executive privilege and attorney-client privilege and marshaling all of the files that had to be marshaled and all the rest of it. And he said, well, I want Dean to take charge of this. I want you fellas to get out of it. He said to me, I've got something else I want you to do, and I want you to press on it. And so I started off on an entirely different project that had to do with legislation. And from about the third week in February, the understanding was that I was out of it. Bob Haldeman was basically out of it, and Dean was the lead man in the White House on this whole subject of privilege, the committee, the grand jury, and all of the collateral questions that were associated with those.
Did Dean make any reports to you after that, or only to the President?
I saw very little of Mr. Dean in those months, and quite a few weeks went by when I didn't see him at all, or for that matter, really talk to him very much. Let's see. In the month of February, after the President made that assignment, I didn't see him at all. The month of March, I didn't see him at all for the first 20 days. And then I saw him in connection with the Hunt blackmail twice, on the 20th and the 21st, but that was the only subject that was discussed. And then, of course, there was the meeting on the 22nd with Mr. Dean and Mr. Mitchell, and then the President. Then, from then on, I had virtually no contact with Mr. Dean except one meeting in Mr. Haldeman's company the day we got back from San Clemente, the 8th of April, once on the 10th of April, pardon me, and then this meeting of the 13th of April, for which the notes exist that are in Senator Inouye's hands.
Just one further question on that. Was there ever any suspicion in your mind that the President appointed Dean to sort of be in charge of Watergate on February 27th because he might have had some suspicion that maybe you were involved, or Haldeman involved, or somebody else in the White House involved?
Well, what the President explained to me was that the central question here was one of executive privilege and the availability of presidential assistance to testimony before the Congress. You recall this had come up in the setting of Peter Flanagan and coming before the Judiciary Committee. And through my notes of meetings with the President, there are 3 or 4 references to the President's strong concern that Haldeman and I were test cases, so to speak, of the availability of presidential assistance to testify before the Congress. And I know there were some questions about his reference to us as principals. I think you have to take it in that setting. We were principals on the question of the availability of assistance to testify. Now, the precedent that might be set by our testifying, he was concerned, would in turn open up Henry Kissinger's testifying and the whole panoply, so to speak, of presidential assistance. And very soon you would have a breakdown of the White House staff system because everybody would be up here testifying like cabinet secretaries do every day, and you couldn't get any work done. So basically, he thought that was where one drew the line, and he wanted Dean to focus very hard on that. I don't think on the 27th that the President was advised of any implication in this matter of either Mr. Haldeman or me. And in point of fact, he continued to be confident through the 30th, I know, and as a matter of fact, on through the 16th of April, because he had a report from Mr. Peterson, the Assistant Attorney General, and from the Attorney General to the effect that neither Mr. Haldeman nor I were criminally involved in this matter in any respect. So, and that was on the occasion of their meeting on that Sunday, which would have been the 15th, wouldn't it? I don't think, particularly the 27th of February, but continuing on through the next 3 weeks, that he had any real concern about that.
Well, you mentioned meetings with Dean, so I guess it's a good time to go to those. Let's go to this meeting between you and Mr. Haldeman and Mr. Dean following the March 21st meeting of Dean with the President. That's when the roof sort of started to cave in. And I'm curious to know what transpired in that meeting between the three of you after the meeting between Dean and the President, when presumably, according to Dean's testimony, substantiated by Moore and what Dean told Moore, Dean told the President everything he knew about Watergate. Then there was a meeting, as I understand it, between the three of you.
There was a meeting at 3:45 on the 21st.
Yes.
And then that meeting moved to the President's office after about an hour.
Now, could you describe first what happened in your office? It was in your office, wasn't it, the first meeting?
I'm not sure. I don't recall.
I have in the log here 3:45 to 6, Dean Haldeman. That's the only thing it says. It doesn't say where. Although there's another note that day of a meeting that says Haldeman's office, so I would assume perhaps this 3:45 meeting was in your office.
I don't know, and
that's
my notes don't show, but in any event, it was either in Mr. Haldeman's office or mine, I'm sure. The conversation...
Who called the meeting? Do you remember?
No, sir, I do not. I do not. The conversation, as I recall it, largely involved the question of testimonial availability of White House staff people. It was this continuing question that was ongoing. Mr. Dean did not report in my hearing what he had told the President that day.
He never mentioned anything about his meeting
with
the President?
He did not that I can recall at all. We were largely taken up both at that meeting and continuing in the meeting which took place in the President's office afterward, with the question of how to get the story out, number one, how to get White House people to testify fully, under what circumstances, whether they should be made fully available to this committee, waiving all privilege, or whether they should be made available fully to the grand jury and not to this committee at all, whether the attorney-client privilege still existed as to Dean, and he talked to us quite a bit about the law of attorney-client privilege, as I recall, at that occasion. And so it was that setting. Now, Mr. Dean and I got into a difference of opinion at that time about the question of immunity and how that should be handled. As I recall, right around this time, I think...
Now, what do you mean about immunity?
Well, his theory was that the President should negotiate blanket immunity for the White House staff with the Attorney General so that the entire White House staff, lock, stock, and barrel, could testify freely before the grand jury as to any and all facts and clear the air, and everybody be immune from prosecution. That just didn't make any sense to me from either a practical standpoint or a public appearance standpoint. And we got into a difference of opinion on that.
Well, now...
That was again... Pardon me, sir.
Well, why did he say that?
Well, he was looking for formulae. He had come up with a concept that there ought to be some kind of a commission, an independent commission that would be set up.
But when somebody talks about immunity, obviously they're afraid of ending up in the pokey. Did he say, now we're all going to jail,
No.
so we'd better get some immunity here?
No. He said that he was concerned that people would not talk freely. Now, Mr. Dean is an immunity expert. Mr. Dean told us early in the game that he was the author of the statute, which the Congress eventually adopted, granting immunity to people in certain criminal situations so that they would testify against hires-up or co-conspirators or whatnot. And so he gave us quite an accounting of the difference between use immunity and transactional immunity and the various technicalities of this. And he explained that immunity was the sort of the lubricant that was needed in this thing to get people to come forward and to fully tell their stories. Now,
but if everybody is innocent of everything, and
well, I don't think at that
stopped with Liddy, why would people worry about immunity?
Well, I don't think at that stage that there was any necessary assumption on our part that everybody was innocent of everything. I think it was implicit in the conversation that there were liabilities. Now, we were thinking in terms of Mr. Magruder, we were thinking in terms of people at the committee, but Mr. Dean was also implying to us that people in the White House would not come forward and testify freely without immunity. This was a line that picked up, I guess, about this time, and then was replayed over and over in his conversations with Mr. Haldeman.
Now, did he mention to you in this discussion who would need immunity in the White House?
No, he did not.
No names were mentioned at all?
No, sir. Not that I can recall. Now,
who did you think might? Because you had some discussion on this.
I don't think that I thought who might at that point. Bear in mind, I had been totally out of touch with this situation for some period of time. My reaction to his proposal was to simply say to him that was out of the question, that we simply could not expect anybody to grant immunity either on a blanket basis or on an individual basis to anybody in the White House. Now, I said that rather early in the conversation, and that may have inhibited any specifics that Mr. Dean otherwise might have been willing to come forward with. But
what was Mr. Haldeman's reaction?
He didn't express a reaction that I can recall to that. He was concerned, as I recall, with the general subject of executive privilege because he'd been hearing from Mr. Mitchell strongly about executive privilege, and he conveyed to us Mr. Mitchell's strong feeling that the executive privilege position that the administration was taking was untenable.
And he didn't say anything about this conversation. He'd had this long conversation earlier in the day with the President of the United States.
No, sir. He did not.
Did you know at that time about who may have been knowledgeable about the break-in? At some point in time he told you that some people knew about it.
Oh, no.
This was later.
That developed as a result of phone calls that Bob Haldeman was getting while we were in San Clemente following, I left...
I don't want to get bogged down on that.
Yeah, I left about 5 or 6 days later to California. While we were out there, we began realizing there was a strong conflict between Dean and Mitchell on this whole question of people going to the grand jury or the committee and so on. And we couldn't get a feel of it. I didn't know what was behind it, and I began trying to find out what was behind it. And then I talked to Mr. O'Brien, and that is the first that I knew about these 4 meetings back in November and December and January and February where these plans were laid. Then I began inquiring through Mr. Moore and others as to what Mr. Mitchell might have testified to that was worrying him and why he didn't think Dean ought to go near the U.S. attorney or the grand jury and what his concerns were.
Is it fair to say that up to this March 21st date, you had no knowledge of what Dean's activities were in connection with Watergate? Now I'm talking about possible illegal activities, other than the Calmbach business and this talk you had on executive clemency. Is that the fair thing to say?
I didn't know what he had to do with the Calmbach business except in the recruiting of Mr. Calmbach.
Well, I'm only talking about what's transpired here in this week.
Right. I do not know about what lay behind that in terms of these meetings in Dean's office with LaRue and Calmbach.
But you knew nothing about his activities other than these little bits and pieces that we've mentioned.
Well, in retrospect, I evidently knew about bits and pieces, but I never had enough to alert me to put it together.
Well, all right. Is there anything else that occurred in that 1 hour that we should know? Back to the March 21st meeting in your office, Haldeman.
You will get better information, I think, on that meeting from Mr. Haldeman, since I believe he took notes during the meeting. I did not.
What transpired in the President's office now when you moved the meeting over there?
There was virtually a replay of difference of opinion between Dean and me on the question of immunity for the White House staff. The President was advancing a premise at that meeting. Everybody goes to the grand jury. Nobody goes to the Senate committee. And we go to the grand jury right away, and the White House staff marches down there in platoons if necessary, and we get it all cleaned up. And if there's any problem, why, the problems are smoked out.
Was that the decision when the meeting ended?
No, I say it was advanced as a sort of a premise for argument. And Mr. Dean said, well, that's what I've been saying. We ought to do that. We ought to do it under a blanket immunity, and that way all the truth will come out. And I was saying, I just think that's wrong, number one. I don't think anybody in the White House is entitled to immunity. If they've done something wrong, then they ought to take a penalty. More than that, I think it would be just terribly misunderstood by the American people.
Now, what was Haldeman's position?
You'll find that throughout these kinds of things, Mr. Haldeman seldom, if ever, takes an advisory position.
He just listens?
He listens, he takes notes, he undoubtedly gives his opinion, but he doesn't usually give it in an open meeting.
Of course, he must have realized that he was involved in some way here. I should think he'd have some opinion upon his future in a very important meeting like this.
I'm not sure that either he or I had any real appreciation at that point in time that we were, in fact, involved in this, as you put it.
Well, but we do have the evidence that he instructed Strawn to shred some papers that might have some light on this.
Senator, I must say, that story has arisen in the last 6 weeks, as far as I know.
I'm not saying you know anything about that. I'm simply saying I'm surprised that Haldeman didn't know.
I don't think he knew about it either. I interviewed Strawn at great length, and my notes are here. And I asked him, because I was trying to find out about Mr. Haldeman, frankly. I said, tell me everything you know about how Haldeman might be tied into this thing. And he gave me 4 or 5 instances of some contact that Mr. Haldeman might have had with the Watergate business. There was not a scintilla of a mention of shredding documents anywhere in that.
What you're saying is that we may get different testimony from the next witness.
Well, I'm saying too that as we sat in this March 21st meeting, I don't think Mr. Haldeman or I had any contemplation that there was going to be a suggestion of our implication.
Well, now, what did the President say to this difference of opinion between you and Dean on immunity?
He said that he would like to have us have a meeting with John Mitchell and sit down and talk with him not only about that, about the basic question of whether staff should appear here or at the grand jury or both, but also recasting the administration's approach to the question of executive privilege, because he knew that Mr. Mitchell had very strong views on that.
And did the meeting end on that note?
Yes, sir.
All right, now the next day you did have such a meeting, did you not?
Yes, we did.
With the 3 of you and Mr. Mitchell.
Right, and then that meeting likewise went over to the President's office in the afternoon.
Will you describe those 2 meetings?
I was in only a part of the first meeting, which was held in Mr. Haldeman's office. That was the day that Secretary Schultz came back from the monetary conferences, and we were in the midst of a re-examination of Phase 3, the economic program, and I was sent to the airport to meet Secretary Schultz, ride back with him in the helicopter and the automobile, bring him up to date on what the President wanted to meet with him about, and arrange for a time that afternoon when the Secretary could come over and we could have a further meeting and get into the work that had been in progress during his absence. The Undersecretary, or I guess it's called Deputy Secretary of Treasury, Mr. Simon, likewise rode back, and we had that session. So I rejoined, the Dean Mitchell-Haldeman meeting not too long before it went over to the President's office.
What transpired while you were there?
Sir?
What transpired while you were there?
While I was there was largely a discussion of executive privilege. And Mr. Mitchell's views that the Kleindienst testimony, I don't remember whether he testified, but anyway, the administration position had been too restrictive, and that it was untenable both, he thought, from a legal standpoint and also from a political standpoint.
Now, again, in this meeting, in the President's office, there was no discussion of the gory details of Watergate?
There was not. There was not.
Just the technicalities of perhaps how to bring out the whole story.
Well, when the four of us went to the President's office, again, it was largely how to get the whole story out. The question again of the grand jury, of immunity, in John Mitchell's presence, with the President trying these various things out on John Mitchell, and it finally ended up with the President assigning to Mr. Dean that he wanted Mr. Dean to sit down and write out a statement as completely as possible of the facts of this whole subject matter.
This is why he went to Camp David some time later.
Apparently, and that's what I was told, that he found it impossible to do this job with the Gray hearings going on and the distractions and Mr. Gray making accusations against him and so on.
This really puzzles me. Here on March 21st, that's the day before we're talking about now, supposedly from the testimony we have from Mr. Dean and the testimony we have from Mr. Moore that Dean told Moore. Dean told him all about Watergate. That is, all Dean knew about Watergate. And then there's a meeting in the President's office between the President and Dean and you and Haldeman. And then there's another meeting between the three of you and Mitchell. And then you join the President. This, of course, is the next day. Didn't the President say in any of these meetings, now listen, fellas, I've heard all about this from John Dean. What gives here? What are we going to do now? What plan do you have? Who's going to do what? How are we going to get this out? We've got to do it. No discussion of that?
Senator, I have great difficulty in believing that the President was told what Mr. Dean says he was told because of the President's approach to this, which I saw in these two meetings. Now, I don't know what Mr. Dean told him. I guess Mr. Haldeman was in one of those meetings, or part of it, and maybe he's in a position to tell. But
he never told you anything about what transpired in the meeting between the President, Haldeman, and Dean. Haldeman did.
Well, he told me that what Mr. Dean's testified to is not true. Now, I am forced to the assumption by the President's conduct afterward that one of two things was taking place. Either he still confidently believed that the White House was without blame and that Mr. Mitchell was without blame and was acting accordingly, or he was involved in setting a few snares on the trail and was playing it cool because he did not get into any of the January, February, March planning meeting business or the involvement of John Mitchell or any of those kinds of subjects which presumably Mr. Dean had laid all out for him if you're to believe Mr. Dean.
You mean, put it another way, he was in the process of getting the information out from everybody, is that right?
It would be one of the two. And the assignment to Mr. Dean to go and write all this down would fit that hypothesis. In other words, he wasn't going to move against anybody until he had this down and could see what this fellow really had and then would go for it.
Well, now, round about this time was somewhat later, and there are so many meetings here, I've really forgotten which occurred when. So perhaps I'm going to have to rely on you for that. But did the President lift the phone up any time and say, John, I want you to come over to the office here and talk about Watergate, what you know about it?
No, sir, not until way late in the game. He lifted up the phone one day and called me down and said, I am satisfied that John Dean is in this so deeply. that he simply cannot any longer have anything to do with it.
That's when he transferred the assignment to you?
Yes, sir.
And what date was that?
March 30.
And tell us again precisely what transpired in that phone conversation beyond what you have already.
Well, that was a meeting in the President's office on March 30, and it was, as I recall, quite brief. We we were getting ready to leave that same day, as a matter of fact, for California, and he called me down. I'm looking for the time to help me recall the time of departure here. Yeah, we left at 3 o'clock in the afternoon. We had a long meeting that morning with Secretary Schultz and Mr. Sonnenfeld about the economy, and that ran from 9 to about, I don't know, what, 10 or 11, something of that kind, a long session, as I recall. He called me down for just about 10 minutes at noontime and said what I've just told you. And I've said, well, what is it you expect me to do, basically? And he said, I want you to step into what Dean has been doing here. I need to know about executive privilege. I need to know about attorney-client privilege. I need to know, have somebody set this strategy with regard to testifying at the committee and the grand jury and these other places. And I need to know where the truth lies in this thing. And the only tip-off that I had to that was a request from him on the 27th, I believe it was. Yes, on the 27th.
Was that the meeting between 11 and 1 with the President?
Yeah, I believe it, yes. Yes, indeed. That was for the purpose of dictating to me a list of questions that he wanted put to the Attorney General. And I believe that telephone call to the Attorney General, which actually was not completed until the next day because he was traveling, is in your file. Phone call with Klein East on the 28th. And I then went down a handwritten list of questions that the President had put to me about the progress of the case, about the involvement of John Mitchell, any possible evidence that Klein East might have, any possible evidence of anybody else being involved at the committee to re-elect, any evidence of any White House staff being involved. And the President told me to tell the Attorney General that if he had any such evidence or if he developed any such evidence, that he was then to transmit it directly to the President, not through me, not through anybody else at the White House, but direct to the President. And that message I did, as you see in the transcript there, I did transmit to the Attorney General.
Excuse me. Do we have those questions that he...
No, sir. You do not. They are a part of my notes of the meeting of the 27th, which are in the President's file.
How many questions were there?
Well, there are about 10 or 12 topics, I think, written out on a piece of paper.
And would you give us, to the best of your recollection, what the topics were and what the questions were?
I think I can do that best, Senator, by looking at that telephone conversation, and because I think that transcript is quite faithful to the list. I just went down the list in talking with the Attorney General, and I don't seem to have that in my...
The telephone?
The telephone call with Mr. Kleindienst on the 28th.
I wonder if the committee would hand this to the witness, Mr. Ehrlichman. That apparently is it. We have another copy. I wish I could have it too, but I think it's better you have it at the moment. Still,
we may have a copy of it here. I may have stuck it back in the file. Thank you very much.
Thanks. I have a copy here
now. Actually, the first sentence, as I recall, is only partly on this transcript, and it said there are a number of things the President wanted me to cover with you, and only the latter half of that sentence is in the transcript.
And if we could, Mr. Ehrlichman, this is very important, but if you could summarize these as briefly as you can, it'll help out the committee, because I think my own time is running out here.
you'll see in the fourth paragraph, I said, number one, he wanted me to ask you these two things that I did yesterday about the grand jury and about Baker, meaning Senator Baker. And then we go into an inquiry about some statements that Senator Weicker had made to the press, which the President had asked Pat Gray to check into. Then, and the President wanted a report on whether Senator Weicker had any evidence or not to support these assertions. Then,
I think perhaps you'd better explain a little more about Senator Baker, who is not here, so we can know that there's no...
Well, the President had designated John Dean as the White House contact on Watergate, or the White House lead man on Watergate, as I say, back in February. He had also designated the Attorney General as the administration contact to the committee, and had asked the Attorney General to be in touch with Senator Baker with regard to committee rules and technical matters of that kind.
This was just a liaison
Yes,
matter,
sir.
so he could find out what was going on, what the committee planned to do, that sort of
That's
thing.
correct. And so he was asking for a report from the Attorney General on that. By the way, it comes back to me that in the meeting that Dean and Mitchell and Haldeman and I had in the President's office on the 22nd, that the President had picked up the phone and called the Attorney General and had given him some questions to ask Senator Baker about committee timing and that kind of thing, so that he would be advised of the facts. And he had not yet had the report back from the Attorney General on that. Then this first page is about Senator Weiker's statements, which was one of the items on the list. Then at the bottom of page 2, I said, the President said for me to say this to you, that the best information he had and has, is that neither Dean nor Haldeman nor Colson nor I, nor anybody in the White House had any prior knowledge of this burglary. He said that he is counting on you to provide him with any information to the contrary if it ever turns up. And you just contact him direct. Now, as far as the committee to re-elect is concerned, he said that serious questions are being raised with regard to Mitchell, and he would likewise want you to communicate to him any evidence or inferences from evidence on that subject.
I think we had better stop there. The chairman points out to me we do have a vote on the Senate floor.
Another floor vote, this one dealing with railroads, has interrupted the hearings. Public television's coverage of the Senate Watergate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
Picking up the hearings again, Senator Gurney is going over John Ehrlichman's investigation of the Watergate that he conducted for President Nixon.
This is going to take some time. I don't want to follow this. I just assume to come back here later.
Well, you can go as long as you can, Ed. I mean, for a while. The Senator Gurney will resume the question of the witness.
Well, I think we were there at the bottom of page 2. Mr.
Yes, sir.
Ehrlichman.
I see in the recess that I had skipped over the Attorney General's remarks in the middle of page 2, where in response to my general inquiry, and the previous inquiry also, he said that he has been emphasizing publicly that the President wanted the matter investigated to let the chips fall where they may, but secondly, that if anybody has any information, we not only want it, we expect to get it so that we can investigate it and, if necessary, indict other people, and that anybody who withheld information would be obstructing justice. That the Attorney General was saying this to the press, and he was getting this out in every way that he knew how. Now, then, at the top of page 3, the significance of the McCord letter, which was drafted by Mr. McCord and handed to Judge Sirica and which Judge Sirica read publicly, was discussed and evaluated by the Attorney General. Then we returned to the question about whether or not Mr. Mitchell were involved. And that led to a statement by the Attorney General that if Mr. Mitchell were to be involved, and he says here that he has no evidence at this time that he is, but if he were, that we should give some thought to, in such an event, to having a special prosecutor, that the Attorney General would feel that he would have to recuse himself. Then I asked him for the President's information, what the procedure would be for such a thing, and the bottom of page 3 and the top of page 4 down to the middle of the page, he describes that procedure. And then we discussed, and again, this is an item on my list, the matter of immunity. Who determines whether immunity will be granted mechanically? And he said the Department of Justice determined that insofar as the grand jury was concerned, but insofar as the Senate committee is concerned, that it made that determination in conjunction. I don't think he said in conjunction with the court, but that these were two separate procedures. Then another item on my list was the status of the court action, which I've referred to previously in testimony here, in answer to a question by Senator Weicker. And then finally, I was asked to tell him that there was a possibility that the President wanted to see him in San Clemente the following Saturday. The Attorney General at that time was in Arizona and was planning to be in Los Angeles, and in point of fact, that meeting did take place in San Clemente subsequent to this phone call.
Now, did the President tell you at the time he gave these questions to you why he was asking you to inquire of the Attorney General rather than Mr. Dean? Did that come up?
It did not come up, and I did not ask.
But in retrospect, do you think it was because he was having perhaps doubts about whether he was getting a full story or not?
Yes. Up until then, Mr. Dean had been the contact with the Attorney General in matters of this kind.
And then on what date did the President give this full assignment to you to run Watergate down for him?
2 days later.
I think I'd better stop there, Mr. Chairman, because I've taken my time.
Well, Senator, I wouldn't want to cut you off. This is a very serious investigation we're making. If you feel that you should ask further questions, I think you should, but we could very well. You could proceed till noon if you have further questions, and then we can recess to lunch hour.
All right. Thank you, Mr. Chairman. Let me then complete, if we can, the assignment you had from the President to now be the sort of chief Watergate investigator in the White House. Would you tell the committee about that, what you did and what you found and what you reported to the President?
I have tried to disclaim the designation investigator, Senator, because I don't consider what I did to be an investigation to conclusive result.
Well, you certainly can define your role.
Right.
I didn't mean to imply something that you weren't doing.
I had to get up to speed on this. I was not following the law of the matter, and so the first thing that I did in another conversation with the Attorney General is to arrange to have someone in the Department of Justice prepare for me a thorough brief of the laws of attorney-client privilege, executive privilege, obstruction of justice, and all of these subjects that we seem to be encountering in this.
Who is that?
A man named Axel Clyburn.
Clyburn?
Clyburn.
Clyde Boomer.
Yes, sir. I can't.
Oh, perhaps you can try to spell it, Mr. Ehrlichman.
K-L-E-I Boomer. First-rate young man, good lawyer, who did just the briefing, and he moved to me by courier at San Clemente a great deal of very useful legal reading, and I spent the first 2 or 3 days out there in trying to assimilate some of this background of law.
What dates are these?
Oh, this would have been the 2nd, 3rd, 4th of April, along in that period. Now, the Attorney General had been at San Clemente on the 31st of March, and I had had a brief meeting with him at that time, and then he had had a private meeting with the President that day. And then he left. Finally, Mr. O'Brien's arrival at San Clemente.
Did you and the Attorney General discuss Watergate at all?
Discussed the fact that I had this assignment.
But nothing of substance about facts?
Not facts as such. He indicated in this conversation on the 28th, just 2 days before, or 3 days before, that we had everything he had, in effect. That's the substance of his responses here. And that continued to be the case in the brief conversation that I had with him before he saw the President. I told him that I was trying to get on top of this, that I would need some help, some briefing help. He said he'd find the best guy he could, and he did, so we got into it. Mr. Clybomer sent me 2 big notebooks of brief, and as I say, that was sort of heavy going, and I just sat and read. With Mr. O'Brien's arrival, however, that was my first interview, and it brought me a whole new picture of this whole matter. A lot of information in what Mr. O'Brien gave me that I had never heard before.
Now, you have recounted most of that to the committee, haven't you?
No, I'm not quite through.
All right.
There's quite a bit of business in those notes about money, about the involvement of people who had various funds of money and carried money around, and who got money and how Liddy got money and this kind of thing, which was all a brand new subject to me at that point. I reported in quite sketchy detail to the President after I had talked to Mr. O'Brien. And he urged me at that point...
Can you tell us very briefly what he told you about these money and other things?
Mr. O'Brien?
Yes.
Yes. He told me about a fund of money that existed at the committee to re-elect, of which he knew, and he had a piece of paper that had a lot of information on it. This was Bart Porter's account, as he called it. It was in cash from Sloan to Porter. About $50,000 of it was pre-April 7 money. 37,000 of it went to Gordon Liddy, and then he has a whole lot of payments out, most of which I believe Mr. Porter has testified to here.
See. Well, let's not go over those that we already know.
Right. Then he told me about some campaign violations, campaign funding violations, which he said the General Accounting Office knew of, which involved nothing over about $10,000, but a lot of different items. He told me about Liddy getting some money for Cuban demonstrators in Washington, D.C., and you've had testimony on that, I guess. And so then I got into the question of who ran the committee to re-elect at various times, particularly during the planning period here. He said that Magruder said he was running the committee, but he was seeing Mr. Mitchell twice a day during this period of time, and he felt it was safe to say that Mitchell was running the committee even when he was Attorney General. Now, that's the balance of the interview with O'Brien, but that gave me a lot of perspective on this thing that I had never had before.
Did he give you any information on the planning of the break-in?
Yes, and I testified with Senator Inouye about that, those 4 meetings and that whole business. Now, I had only one other substantive interview while we were at San Clemente in the remaining 3 or 4 days, and that was with Mr. Calmbach. But I became aware through Mr. Haldeman, who was reporting to me, conflicting conversations that he was having with Mitchell and Dean on this whole subject of should Dean go to the grand jury or should Dean go to the prosecutor. And we began trying to understand what lay behind this. Well, I had the background of Mr. O'Brien's interview, and we zeroed in on the fact that it had to do with these 4 meetings, or 3 meetings, or whatever there were, and whether or not Mr. Mitchell might have some exposure for perjury on account of having testified that the meetings were canceled or not.
Yes.
And so I had Bob Haldeman try and get a straight answer out of Mr. Mitchell, and he said he couldn't, and so I called Dick Moore and asked him if he would talk to John Mitchell, because I knew they had a close relationship.
That was the reason for Moore's trip to New York?
No, it was not. This was subsequent to that trip to New York. This was, I believe, a telephone call which Mr. Moore said he made to John Mitchell, and Mr. Moore, I believe, also talked to Mr. Mitchell's attorney, although I'm not positive of that. But in any event, Mr. Moore reported back that Mr. Mitchell was confident that he had not in any way violated any perjury statute, and that he just didn't think it was a good idea for the president's lawyer to be going out and testifying. In other words, it was an attorney-client privilege kind of a position that he was contending for. That didn't satisfy me.
Mitchell now talking about Dean shouldn't testify.
That's correct. That's correct. This thing continued to be a nagging question, and so we called John Dean as we were headed back. I talked to Haldeman further about this. Dean was not talking to me all through this period of time. I had not phone call one from him, which was fairly unusual, because I used to hear from time to time on various subjects, including Watergate. But I was completely not on his telephone list, and Bob Haldeman was hearing from him all the time. So we talked about what Bob Haldeman...
Did he know that you were performing this role for the president?
I believe so. I believe so. I did not tell him, but I think he well knew it. Matter of fact, just before we departed for California, this question arose of Mr. Dean being fired by his law firm for unethical conduct, and I sent for his personnel package in order to check it. The personnel package arrived in Fred Fielding's arms with Scotch tape around it a number of times, and he said, "What do you want this for?" And I said, "Well, there's a story." And that refreshed my recollection. I did have one phone call with John Dean, and that was on that subject. He did call me at San Clemente about that and said, "I understand that you wanted to get my personnel package." And I said, "Yes, there's this story about your having been accused of unethical conduct." And then he told me the long story, which he recounted to this committee, about how eventually he was able to get the attorney who charged him with that to retract the charges, which satisfied me. But I think through Fielding and through my conversation with Fielding on that occasion, Mr. Dean must have known that I was actively in this. In any event, on the way back, we called and asked John Dean to meet us in my office when we returned to Washington that night, and he did so.
What date?
Well, 9th, 8th of April.
April the 8th, between 5 and 7.
Right. That was a Saturday or Sunday. That was a Sunday night. And we had a two-hour meeting, Bob Haldeman, John Dean, and I, to try and understand what this hang-up was between Mitchell and Dean, because we still didn't have a feel for it. And then, for the first time, Mr. Dean talked to us about the 4 meetings, or the 3 meetings, back in January and February, and explained some of the nuances of the cover-up story with regard to Mr. Magruder and a meeting which he, Dean, Magruder, and Mitchell had in Mr. Mitchell's law office at a time when they were gathered with the attorneys in the case to discuss grand jury testimony, where the 3 of them had retired to Mr. Mitchell's partner's office away from the attorneys and had discussed how to reconcile their respective recollections of the events of the early 1972 period. So that was the first time that I had from Mr. Dean directly this subject matter.
Did he talk to you at that time about his orchestration of the perjury of Magruder?
He did, but he did in very delicate terms. He did not in any way admit to me flatly that he had, in fact, orchestrated it to perjury. He indicated that he had had a part in the preparation of the testimony, that there were, well, I've forgotten how, it was a very careful explanation, which did not really implicate Mr. Dean in suborning to perjury by any means. But he indicated that he was well familiar with the problems between Magruder and Mitchell on the one hand. He felt that Mr. Mitchell had problems which were causing Mr. Mitchell to say that Mr. Dean should not go and talk to the prosecutor or the grand jury. And so this was very thoroughly discussed and hashed over during that meeting.
And these problems between Dean and Magruder, specifically, did they involve who was responsible for the break-in and giving the green light to it? Is that what you mean?
I gathered not. I think they involved disputes in their recollection as to what took place at these Liddy meetings, so-called, back in the early part of 1972.
I see. Did he go in at that meeting to any detail about his own involvement from June on? Dean, I'm talking about. Cover up to.
We talked, no, not in evidentiary terms at all. We talked about the president's desire. The president on the flight back, as I recall, we had a meeting on the flight back of about nearly 2 hours about this, and the president decided that he wanted Mr. Dean to go to the grand jury. And so we conveyed that to Mr. Dean at that time.
What was his reaction to that?
He was still very much interested in the question of immunity. He had some information, as I recall, about how the prosecutors felt about the White House, and so he imparted that to us, that he didn't feel that anybody in the White House was a target of the prosecutors, that they were after some people who had obstructed justice, like Mardian and LaRue and people at the committee, but that he, Dean, felt that something like an estoppel or functional immunity or something could be worked out with the prosecutors if he went to testify, and he seemed generally in agreement with the idea that he go and testify.
Was there any discussion at that meeting about your role in Watergate or Haldeman's role in Watergate?
That did not come until this meeting of the 13th of April.
Well, could we go into that?
Yes, sir. On the 13th at 2:30 or 3 o'clock in the afternoon, I had a conversation with Dean, which was apparently as a result of further contacts which he had had with the prosecutor. He told me that Liddy had talked with the prosecutors off the record very completely, and that they might get him to talk on the record. That his attorney was going to try and get Mr. Mitchell to support his view that Liddy ought to talk on the record. And it turned out that that was incorrect, apparently, but that was at least what he told me. And I suspect what was happening here was that the prosecutors were telling him this, to try and get him to move to come forward and make a disclosure. Apparently the prosecutors were playing this kind of a game with a lot of these people at that time, saying so-and-so has talked, so you better come and talk, and passing this word along. He told me that Hunt was back testifying before the grand jury at that time, but lying. That the grand jury was also taking testimony, or the prosecutors at least, were taking testimony from Strawn and McCord, that there would be no indictment of anyone in the White House. That at all costs, he felt, special prosecutors should be avoided in this case. Because of the involvement, he said, of Caulfield and Krogh. Now, I didn't get the significance of that at the time, but presumably that referred to some of Caulfield's intelligence gathering activities and Krogh's involvement with the plumbers. He said it's a close question as to my Dean's liability. and I have a note there that says, then some before grand jury, but I don't know what that means anymore. It doesn't recollect anything to me. He said, they won't subpoena me, but it's better if I cooperate. Now, he went back into the meetings in Mitchell's office about money. I was inquiring of him now about cover-up money. He said that the way Dean got involved, was that Mitchell requested me to help. He said LaRue and Mr. O'Brien would urge that money be made available. Mitchell would postpone making a decision until the last minute, and then the way he would get this thing off his desk would be by calling me, Dean. He said the U.S. Attorney doesn't want to cause the White House problems. They tell Dean that Magruder and Mitchell are involved in the pre-Watergate matter, and that LaRue, Mitchell, and Mardian are involved in the post-Watergate matter. He said, I don't think Jeb can crack a deal, meaning a deal with the prosecutors for immunity. Then I have a little symbol on these notes which summarizes the exposure which he thought that Bob Haldeman and I had in this matter, mine being my connection with Herb Calmbach in the provision of money for the defendants, and I have the number 350, which relates to the $350,000 fund, which presumably involved Bob Haldeman. He said neither one of these are indictable, but they're going to be awkward to explain. He said I don't think either one of them are a problem for you in an ultimate sense. He said the probable scenario for the future will look about like this. May 1st, the grand jury is going to break this case. About May 15th, there are going to be indictments. Then the Attorney General is going to go to Senator Ervin and tell him that the hearings are going to prejudice the new case and that they couldn't possibly get a fair trial. He'll ask that the hearings be held off a month or two until the trial is over, and then he said, in my personal opinion, if they are held off, then there never will be Senate hearings. He said, I don't know what John Mitchell will do, whether he would take a plea or what he would do under those circumstances. Almost surely, if John Mitchell's indicted, Kleindienst will resign, and he said, I think that Joe Snead ought to be acting Attorney General. Then he said, the U.S. Attorney has assured me that I am not a target, and neither is any other White House person.
Were these notes made at the time of the meeting?
Yes, sir. As we talked.
Did he tell you about all his involvement with the Calmbach raising of money and these methods of paying it that Lasowitz told us about?
No, sir. That I hadn't heard until this testimony here.
Well, the contacts he was having with LaRue at this particular time.
No. You recall he testified in about 5 different ways about looks of anguish, disbelief, scorn, whatnot on my face at the time he said that I was indictable. In point of fact, at the time he said I was not indictable, but that the Calmbach thing might be a problem for me and being misunderstood, I said, well, I just don't see how it could, John, and then we discussed just that, the assumptions which I had made that there was nothing improper about it and so on.
At one of these meetings, and I can't remember which one it was now because there were several in this time frame, but Dean testified, as I recall, that there was a discussion between you and him and I think Haldeman on the fact that the best way to settle Watergate would have Mitchell come forward. I guess that March 21st? March 21st, counsel tells me. Do you recall anything on that, whether there was a discussion or an agreement between you that that was the best thing to do?
There never was such an agreement.
Was there a discussion?
During that meeting and during subsequent meetings, both meetings between Mr. Haldeman and me and meetings with Haldeman, Dean, and me on the 2 occasions that I think we had them subsequent to that, there was a lot of speculation about John Mitchell and his place in all of this. And, of course, he was he was not saying anything to anybody at that point in time, and none of us really had a feel for this. I can recall at one of these meetings, Bob Haldeman saying, "I wonder if we're taking all this anguish just to protect John Mitchell." He said, and it was a question; it was not an assertion. But I think we all shared at various times that question in our minds as to whether the beating everybody was taking on the subject of Watergate was because he was not coming forward. Now, that was one of the reasons that the President asked me to meet with Mr. Mitchell on the afternoon of, Saturday the 14th of April, to say to him, for the President, that if Mr. Mitchell thought his silence was somehow serving the presidency, that was a misapprehension, that the President didn't want him to sit silent if he knew something, unless Mr. Mitchell felt from his own personal standpoint that was an exercise of his own rights, in which case that was up to him. And I delivered that message to him at that time. But that was a continuing question all the way through this period of time.
Now through this period of time, beginning with that assignment on, is it March 31st?
30th, sir.
30th, March 30th. Were you reporting to the President what you were finding out?
I reported to him after I talked with Mr. O'Brien, but very, very briefly on that subject. And it just said, I'm beginning to get a feel for this thing, but I've got so much hearsay here, I don't think it's worth taking a lot of your time. And he said, well, what are you finding out? And so I said, well, he tells me there were these meetings back in the early times, and Liddy had this plan and so on. And I took him kind of sketchily through the O'Brien business and said, look, this is all hearsay 2, 3, and in some cases 4 times removed. And I said, we cannot move on something of this kind until we find out. Now, in San Clemente again, when we came to this funny conflict between Dean and Mitchell, I mentioned that to him and said we were trying to get to the bottom of it. And 2 or 3 times he said, have you got that figured out yet? And when we talked in the airplane going back, and we talked about Dean going to the grand jury, and he said, finally, well, I'm not going to wait. He's going to go. He said, have you ever figured out what that is? And we said, no, we're going to see Dean. We don't know what that is.
Well, now, did you make a complete report to the President?
Yes, sir.
And when was that?
That was on Saturday morning, the 14th of April.
And what did you tell him?
Well, I told him basically a narrative of my interviews with these various people, starting with O'Brien and running through everybody that's on this list except Mitchell and Magruder, with whom I had not yet talked, and Strawn the second time when I got into the whole question of Bob Haldeman's involvement.
Well, now, so we can wrap this up and I can release the floor here. Did you at that time give him a complete account of Watergate as we know it now? And if you did not, what portions did you not tell him that you didn't know? Perhaps we can get at it that way quickly.
I didn't know, for instance, any of the behind-the-scenes business of the money beyond what Paul O'Brien had given me here and a little feel of it that Dean had given me, which I think I've just described to you about as well as I can. The subsequent interviews that I had with particularly Magruder that afternoon. See, the outcome of this report to the President was, he said, I want you to talk to Magruder, I want you to talk to Mitchell, and then he also told me that he wanted to find out more about Bob Haldeman's involvement. So those 3 followed that preliminary report, and none of the things that I developed from any of them were included in it. When I completed them, then I came back and reported what those 3 individuals had told me and laid that out for him.
And was that a fairly complete account of Watergate?
It included the planning meetings. It included the 2 entries and the reasons for going back. It included quite a lot, but not the whole story of the cover-up by any means.
The fact that there had been one going on without all of the gory details,
right,
perhaps.
And obstruction of justice from both the committee and Mr. Dean's part in it, although I'm frank to say I did not feel sense the full implication of Mr. Dean's involvement in the aftermath yet at that time.
And what date was that?
That was on Saturday, the 14th of April.
And what was the President's reaction?
That I must immediately advise the Attorney General, which I then did within the hour.
And that was the end of the meeting?
Yes, the meetings went on, however, the following day. The President had a long meeting with the Attorney General and Mr. Peterson, who in turn had meetings with the prosecutor. Then I had another meeting with the President because I had seen Gordon Strawn that morning while the President was talking, Sunday morning, while the President was talking to the Attorney General and Mr. Peterson. So then I had a further report to give to the President Sunday following that meeting that he had had.
Can you very briefly tell us the important parts of that?
Excuse me, Senator. Yes. Counsel reminds me that I should say that we're advised that the Attorney General had an all-night meeting Saturday night with Mr. Peterson and with the U.S. Attorney and the prosecutors, and posted himself on things. He then met with the President after church Sunday morning. I met with the President after that. We then had a further meeting later on that Sunday, one or two meetings, I forgot which. I got home and was told to turn around and come back, so I came back Sunday night. We had another meeting at which the President went over and over this information, and I think it was at that time that I called Mr. Gray and discovered that the documents had been destroyed. So then we went over that at length and the implications of that, and I had further conversations with the Attorney General, I guess, the next morning. But this went on over a period of about 4 days, Friday, Saturday, Sunday, Monday.
And then it was April the 17th that the President issues his statement that he was aware of new developments in Watergate.
Sir.
Yeah. I think I'd better stop there. Thank you, Mr. Ehrlichman. Thank you very much, Mr. Chairman.
The committee will stand in recess till 2 o'clock.
During the luncheon recess, Senator Ervin and the other committee leaders met with White House counsel Lynn Garment in the Senator's office. If the subject was national security work done by the Plumbers Unit, no one was talking about it. And when Senator Ervin returned to the committee room, he made no announcement, but went right ahead with the questioning.
The committee will come to order, and Senator Montoya will examine the witness.
Thank you, Mr. Chairman. Mr. Ehrlichman, you have testified that during the period from June 17th or shortly thereafter, up until the time you resigned your position at the White House, that you intermittently kept up with the course of the investigation that was going on in-house, out-of-house, and otherwise.
Yes, sir.
And that shortly after June 17th, according to testimonies presented here by Mr. Strawn, and I believe confirmed by you, you were assigned to be in charge of the investigation shortly after it occurred.
That's not correct, Senator.
All right, give me your version of it.
Well, I think what Mr. Strawn testified to was that in a conversation with Mr. Higbee, who apparently was in Florida with the President on that weekend, Mr. Higbee said that I knew about it or was in charge of it or some such thing. The fact is that on that weekend of the Watergate break-in, I apparently was one of the few senior members of the White House staff who was here in the city. And the rest were either with the President in Florida or somewhere else. And so for the brief time on the Monday, before the President's party got back, and I think they got back late Monday, as I recall, I started the ball rolling. And
what did you do?
I called Mr. Dean, who had just returned from the Philippines, and he and I had a meeting on Monday noon, and from then on, as far as I was concerned, he had the ball.
Who threw the ball to him?
I did.
What instructions did you give him?
I told him that I thought that it was important for us to keep well informed of all of the fast-breaking events in this matter, in order that our press office could be fully briefed and kept up with the developing events. Because as I testified before, I saw this as a real campaign issue.
Did he report to you frequently on what he was uncovering?
I saw him a total of 9 times in the next 2 weeks, which is an unusually large number of times for my contacts with Mr. Dean.
And what did you see him about during those 9 times?
Well, among other things, well, let me just...
I mean, with respect to Watergate.
Yes, sir. He told me a number of things, and I have tried to make a list of them here, and I'll give them to you. He told me about the general facts of the surveillance of the Democratic National Committee headquarters, the fact that the Howard Johnson Motel had been employed as a listening post, the fact that a hotel room in the Watergate Hotel had been found, which had some of the burglars' possessions in it, the fact that they used fictitious names and papers, and that they had large quantities of money and $100 bills. He told me about the fact that Hunt had a safe still at the White House. And then I've testified previously to the meetings the meeting which we held Monday afternoon to try and determine the facts with regard to Hunt's employment at the White House. And that was as a result of a report from Mr. Dean.
Well, did you feel, Mr. Ehrlichman, I don't want to go into all the detail, did you feel that Mr. Dean was telling you almost everything that he was uncovering on a day-by-day basis?
That was certainly my assumption, Senator, yes.
All right. And did this continue even after the first 2 weeks?
No, sir. Before very long, I left the city. I believe it was the 26th, or, well, I'll have to check that. Well, of course, the 24th and 25th I was away. The President went to Harrisburg to see the results of the Agnes flood, and so we were gone those 2 days. And then the 29th, I left for a trip to Springfield, Illinois, Lansing, Michigan, Northern California, and finally ended up at San Clemente.
I think we can save some time, Mr. Ehrlichman. I just want to go through with you over the communications that you had with Mr. Dean with respect to Watergate over the long span up until April the 15th of 1973.
All right, sir. I
mean, in a general way.
I have that in summary form, and perhaps I can give that to you rather quickly. In the month of June, I saw him 9 times, and 8 of those times related to Watergate.
All right.
In the month of July, I saw him 3 times, and only 2 times related to Watergate. In the month of August, 4 times, of which no times related to Watergate. September, 3 times. I'm not able to tell you as to that. One of those meetings was with regard to the foreign grain sales, and I don't know what the other 2 were. October, I saw him twice. Once was a common cause lawsuit, and I don't know what the other one was. November, I saw him 4 times. One was with regard to the Watergate, 2 with regard to Segretti, which I guess you lump into that general subject. December, 5 times, twice on the subject of Watergate. January, 7 times, of which Watergate could be considered to have been the subject of 3 of those meetings. February, 5 times, 3 of which, including La Costa, were on the subject of Watergate. March, 3 times, and one of those times was with regard to the Hunt blackmail. Well, actually, 2 of those were, and the other one, the question of testimonial appearance.
Was that in March?
Yes, sir.
What about the January meeting? Didn't you testify about the January meeting with respect to Mr. Hunt?
Yes, and that's one of the three, or that's actually two of the three that I mentioned.
All right.
And April 3 times, and all of those were Watergate matters.
So, in effect, you met quite a few times with Mr. Dean about Watergate.
Yes, sir.
And would you say that during those times which you met with him, that you discussed fully all aspects of Watergate, White House possible involvement, and also possible involvement of personnel at the CRP?
Well, as it turned out, not. I thought so at the time, but I now know that that wasn't the case.
Well, were you engaging in speculation with Mr. Dean as to who might be involved as a result of these conversations?
On occasion we did.
And quite a few figures or names were discussed during your conversations. Is that not correct?
You mean a great number of people?
Yes.
No, I wouldn't say that, Senator.
Well, then, as a result of all this information and what you independently collected, you used this as a basis for briefing Mr. Ziegler preliminary to any press conferences that you might have had, that he might have had?
Not inevitably, no. There would be times, for instance, when I was not with Mr. Ziegler. I had an independent travel schedule, and very often Mr. Ziegler would have briefings and I wouldn't be available, or he would be out of town with the President and I would be here in Washington.
Well,
but we tried as nearly as possible to talk over particularly technical matters. For instance, when the civil depositions were being taken, Mr. Ziegler and I recall, had a conversation about a civil deposition, what the rules of evidence were, why hearsay could come into a civil deposition where it couldn't come into a trial.
Well, the point I want to make, Mr. Ehrlichman, that you have testified here that on numerous occasions you did brief Mr. Ziegler preliminary to any press conferences that he might have.
Well, I don't think I said it quite that way, Senator.
Well, how did you
say it? What I
say it?
attempted to impart was that on more or less a daily basis, Mr. Ziegler and I would try and touch base about any current issues that needed my assistance, and not in every case would he need my assistance for some of these things. But where we had, for instance, the issue of the Clean Water Bill and the President's possible veto of that bill, where we had the spending limit that was a hot issue in the Congress, Mr. Ziegler and I would sit down and we would talk through what the central issues were, why the President took the position he did, what the other view was, to try and give him a working knowledge of the subject matter. And we tried to do that with various aspects of this case as it went along.
But did you ever brief him on Watergate, on the part or concern of the White House and so forth?
Well, I don't know quite what you mean by brief.
Or did you provide any input
I'm sure that I
into
did.
the background which went into those press conferences?
I'm sure that I did at times.
All right. Now, there were quite a few pronouncements by the White House, by the President, with respect to the Watergate affair. And I'm going to relate those in sequence. On August the 29th, 1972, the President, in response to a question, stated, and this is part of his answer, "In addition to that, within our own staff, under my direction, counsel to the President, Mr. Dean, has conducted a complete investigation of all leads which might involve any present members of the White House staff or anybody in the government. I can say categorically that his investigation indicates that no one in the White House staff, no one in this administration presently employed was involved in this bizarre, very bizarre incident." Then on a subsequent date, the President, in his October 5th, 1972 conference stated in response to a reporter's question as follows. Now, when we talk about a clean breast, let's look at what's happened. The FBI assigned 133 agents to this investigation. It followed out 1,800 leads. It conducted 1,500 interviews. Then, subsequently, during the press conference of April 17, 1973, the President stated as follows. On March 21st, as a result of serious charges which came to my attention, some of which were publicly reported, I began intensive new inquiries into this whole matter. Last Sunday afternoon, the Attorney General, Assistant Attorney General Peterson, and I met at length in the EOB to review the facts which had come to me in my investigation, and also to review the progress of the Department of Justice investigation. Then he stated, as a result, on March the 21st, I personally assumed the responsibility for coordinating intensive new inquiries into the matter, and I personally ordered those conducting the investigation to get all the facts and to report them directly to me right here in this office. That was prior to the time that he assigned responsibility to you to conduct a further inquiry, which was on March 30th, 1973. Is that correct?
Well, I thought that press conference you said was April 17. Is that not correct? That would have been.
Yes, but I'm referring to the date of March the 21st,
oh,
which
yes.
you recited.
Yes, indeed.
Mm-hmm. All right. Now, up to that time, Mr. Dean had been talking to you. Other people in the White House had been talking to you. And there had been quite a few articles in the Washington Post by Mr. Woodard and Mr. Bernstein. And in fact, most of the information about which you were inquiring with all these FBI people had already appeared in the Washington Post. Now, did you read the Washington Post on or about that time?
What time, Senator?
During the course of your different conferences with Mr. Dean, during the course of your different inquiries, were you reading the Washington Post about the what was being uncovered through Woodard and Mr. Bernstein?
Well, I wouldn't certainly want to leave the impression that the White House relied on the Washington Post for reliable information very much of the time. The fact is that our news summary contained digests of what a great number of newspapers were printing, both about the Watergate and other matters.
Well, but as a matter of fact, they were uncovering more than all these FBI people were.
No, sir.
At least there's been no information coming to us that was more accurate than what these reporters were uncovering at the time.
Then I think you're in trouble, Senator.
Well, I think the whole country is in trouble.
I submit to you, sir, that the FBI reports, which we were receiving at that time, on the face of them, and from everything we knew about it, and from everything the Attorney General was telling us about it, and everything that the prosecuting attorneys were telling us, could be relied upon.
All right, now let me ask you this question. You said that you conducted an inquiry pursuant to instructions from the President, instructions which you received on March the 30th. Now, who did you investigate? Who did you interview? And with what objective in mind were you conducting this inquiry?
I was, as I say, it was not really an investigation in the technical sense of the word, and I have declined to identify it as such at all times. But as I said before, the people whom I interviewed included Paul O'Brien, Herbert Calmbach, John Dean, Gordon Strawn, Charles Colson, John Mitchell, Jeb Magruder. I had a telephone conversation with Mr. Gray, which may or may not be considered to be included in that, and Mr. Krogh.
Did you interview Mr. LaRue?
No, sir.
Mr. Mardian?
No.
Mr. Calmbach?
Yes.
Mr. Stans?
No.
Mr. Sloan?
No.
In fact, you turned him out of your office, so to speak.
No, I don't believe that's quite fair, Senator. What I did was, I think, what I should have done, which was to say to him, before you talk to somebody in my situation, go and talk to a lawyer. Since you're the treasurer and you tell me you've got the legal liability for all this and you haven't talked to a lawyer, Duke, go talk to a lawyer first.
All right. Would you say that you conducted very intensive interviews with these people?
As I say, Senator, I can't claim this to be an exhaustive investigation. I conducted, I think, reasonably thorough interviews. They lasted between an hour and 2 hours, most of them.
Were they conducted in your office?
Sir?
Were they conducted in your office?
Not in every case. My principal concern was to try and get a feel for whether anybody in the White House was involved in this. I felt that's the place I had to begin. So most of my questions were not directed to what people like Mr. Mardian or Mr. LaRue did at the committee. Occasionally people told me those things. But my principal focus was to say, what do you know about people in the White House? Do you know about anybody else in the White House who might be involved? Or if they were talking about an individual in the White House, I would say, well, what else do you know about him that might in any way involve him in this? And that was my principal focus. But the other part of my job, other than just interviewing these few people, was to try and get on top of these very complex law questions which Mr. Dean had been working with and which I had not. And it took a great deal of my time, and I might say this was one of the President's principal focuses in this time, was this dilemma of separation of powers, executive privilege, attorney-client privilege, the whole legal underpinning for this process.
If you will pardon me, Mr. Ehrlichman, you testified about that this morning, and I don't want to appear repetitious in my questioning, and I don't want you to appear repetitious in your answers. Now, I'm merely interested in trying to ascertain from you what type of an inquiry.
Yes, sir.
Now, during the interviews which you had in your office, did you, on occasion, tape the conversations with these people?
On 2 occasions.
Which were those occasions?
Mr. Mitchell and Mr. Magruder.
Where are those tapes?
In the possession of your staff.
All right. Now, did you transcribe any interviews? Or arrange for their transcription?
In the sense of sitting down and dictating a summary or anything of that kind?
Yes.
Yes, sir.
And who has those interviews?
Well, I think what I did was to turn over my handwritten notes to the committee staff. There is one such transcription of my interview with Mr. Calmbach, which I don't think that I have given to the committee staff. I'm not sure.
Are you prepared to give it to us?
Oh, yes, certainly, certainly.
Would you do that?
Have they got it? It may be that they have it. That question came up this morning, and I don't think we decided for sure. No. This is a narrative that I dictated after my interview with Mr. Calmbach.
Mr. Dash, did I not give you, I think I gave the U.S. Attorney's Office, less than a one-page memo of a meeting between Mr. Ehrlichman and Mr. Calmbach on April 6, 1973?
Mr. Wilson, I have no recollection of that.
Right now.
I'm very sure not. You may have given it to the prosecutor's office.
What?
You may have given it to the prosecutor's office, but not to this committee.
I always meant to give you the same things. Perhaps I didn't do it.
I know you've tried, but if you have it, we'd like to have it.
Sure. It's in one of your. It's wrapped up in one of your.
Now, who else did you take notes on?
Just those that I mentioned this morning, Senator. Do you want me to go through that list again?
No, I don't. I merely want you to tell this committee what did you ascertain as a result of these interviews with respect to each of the individuals? Did they convey to you any indication that they might have been involved in the Watergate affair prior to June 17th or in the cover-up after June 17th?
Yes, sir, they did.
All right, will you name those names?
Yes, sir. I wonder if I could refer to my notes in order to do that accurately.
Certainly may.
The last one had those? Well, then it's in there, this paper we're looking for. What you got? You got manila?
I haven't. I've got a couple of folders. I had this morning described fully the contents of my interview with Mr. O'Brien, I believe, and also my interview with Mr. Dean. The one which remains, which is responsive to your question, I think, is my interview with Mr. Magruder on April 14th at 4 o'clock in the afternoon. His attorneys, Mr. Sharp and Mr. Bierbauer, were with him at the time of the interview, and they had just come from an interview with the United States Attorney. The interview took about, I would guess an hour and a half. And if you like, Senator, I can just take you quickly through the narrative of what Mr. Magruder told me, or I can pick things out if you're interested in something particular.
Now, just give me your conclusions from that interview.
Conclusions from the interview were that Mr. Magruder, and according to him, Mr. Mitchell and Mr. LaRue participated in an express and specific approval of the plan to break into and bug the Democratic National Committee headquarters. That this was an agreement or an approval which occurred in Key Biscayne at a meeting attended by the three of them, and that in addition to that particular project, McGovern headquarters and the Fontainebleau Hotel headquarters of the Democratic Convention were likewise to be bugged.
What date was this again?
This was an interview which I held on April 14, 1973.
All right. Proceed.
And here you understand that this is what Mr. Magruder is saying to me. I can't vouch for the truth of this, but it's what he reported to me. That the proposal, which was approved at that time, had its genesis in a $1 million proposal, which Mr. Dean and Mr. Liddy prepared. I asked him specifically about Mr. Dean because, as I said, I was focusing on White House people, and his description of Mr. Dean's participation in that planning was quite active. Mr. Liddy told Mr. Magruder, he said, that Mr. Dean had authorized the $1 million figure as the beginning budget level.
Did you, from your knowledge of the White House and the assignment of Mr. Dean, reach a determination that Mr. Dean had that kind of authority?
Oh, no. No, indeed.
You didn't believe that, did you?
What Mr. Magruder was telling me?
Yes.
I didn't know what to believe at this time, Senator. I was getting so many different hearsay stories from so many different people. I wasn't trying to evaluate what to believe and what not to believe.
All right, proceed.
He said that he took me through the four meetings in early 1972
Well,
where
I believe
the-
you testified to that, and I don't want
Yes,
to
sir.
delve into
Well,
repetition.
except that this is out of Magruder's mouth. And then he said that at some point in time, he informed Mr. Strawn, who was his primary contact at the White House, that they had an intelligence capability. He said, I got no problems from Mr. Strawn, and so I read that as an okay from higher up. I asked him whether he had any knowledge of whether anyone higher than Mr. Strawn in the White House had in fact approved this. He said he had no knowledge of any higher-ups having done so. And the only people in the White House that he focused on as having had any connection whatsoever with this were Mr. Colson, Mr. Strawn, Mr. Dean, and Mr. Howard. And
May I interject here? What particular authority did Mr. Strawn have vis-a-vis the White House?
Mr. Strawn was about a fourth-level White House staffer with almost no authority of his own.
Well, what particular assignment did he have during the campaign? I understood that he was going from Mr. Haldeman's office to the CRP and back and forth. Now, did you know of this assignment?
No, sir.
Have you since found out about this assignment?
In the course of these hearings, I've learned a great deal more than I ever learned when I was in the White House.
You mean you didn't find out while you were at the White House about Mr. Strawn's assignment?
I knew almost nothing about the scope of Mr. Strawn's assignment while I was at the White House until late in the March-April period, when I got into it and I began interviewing people, and he was one of the people I interviewed.
Well, what did you find out about him then?
At that time?
Yes.
Oh, that he was the liaison man between Mr. Haldeman and the committee to re-elect for the purpose of keeping both ends of his liaison informed of the acts and desires of the other.
Did you know him?
Yes, sir.
Did you know him to be a very reliable young man?
Well, I didn't know him well enough to form an opinion as to his reliability.
Now, if he conveyed anything to the CRP or brought anything to Mr. Haldeman from the CRP, would you say that he was carrying out his assignment properly?
Oh, I couldn't speculate as to that, sir.
Why can't you?
I just don't have that kind of knowledge. Now, as far as reliability is concerned, something occurs to me that perhaps you ought to know. My first interview with Mr. Strawn was on the occasion of his having just returned from the grand jury. And he came in rather shaken and told me that he didn't know what to do, and he was looking for somebody to give him some advice. He said that he had just come back from testifying to the grand jury that he had delivered $350,000 to Mr. LaRue. And he said, as soon as I left there, I knew that was wrong. I hadn't delivered $350,000 to Mr. LaRue. I had delivered some lesser sum, because I remember that they took some money out, or I took some money out, I forgot how he put it, but some money had been taken out for advertising. Now, what should I do? And I said, well, do you have an attorney? He said, no, I don't. And I said, well, that's the first thing I think you ought to do, is get some advice. The second thing it seems to me that you ought to do, subject to your attorney's advice, is to go and tell the prosecutor you think you've made a mistake in your testimony.
All right.
But that is probably the only real gauge I have of Mr. Strawn's testimonial reliability.
Then, what did you find out about, what conclusion did you reach with respect to Mr. Strawn as a result of the interviews that you had?
That what he told me in the second interview that I had with him, I felt was correct and the truth, and that he was trying very hard to tell me everything he knew. I had a favorable impression of what he told me. That is his attempt to tell the truth.
Well, the point I'm trying to make, did you reach any conclusion from the interviews with respect to him as to whether or not he was involved either in the pre-June 17th complicity or after?
Oh, I see. He told me that he had received from the committee to re-elect notice that they had an intelligence capability. He did, and I confronted him with what Mr. Magruder had alleged, which was that Mr. Magruder had sent over to him a budget which had included specific reference to bugging. And he said no, he would have remembered if anything like that had come over. He was sure that he had never seen anything like that. He said that he did receive from Mr. Magruder some material designated sedan chair. And it looked to him like synopses of wiretap information. Of course, we've learned since that sedan chair was not a wiretap, but that was the only thing he said he received. He said he got no gemstone material at all.
Well, Mr. Ehrlichman, I'm just interested in what you concluded as a result of the interviews with respect to these individuals.
My conclusion with regard to Mr. Strawn was that he was a messenger, that he was not an active planner or executor of any plan, but simply a conveyor back and forth.
All right. Now, what conclusion did you reach with respect to Mr. Calmbach?
Well, my conclusion after talking with Mr. Calmbach, as you will see in this memorandum that we have now given the staff, I take it, perhaps it is best if I simply read you a short portion of that as my then contemporaneous conclusion. That would probably be the best evidence. Do you have that, Counsel?
I gave the only copy I have.
Yeah.
Do you want to just read it?
Well, let me. I'm running out of time now.
Well, all right. Very shortly, Senator.
I merely wanted to get an indication as to what kind of an inquiry you had conducted with respect to each individual.
All right. My inquiry with him was as to his money-raising efforts and whether or not he knew, either directly or whether he knew circumstances surrounding his efforts which might have put him on notice that he was engaged in an effort to buy the silence of defendants. And I was satisfied that he did not know.
All right. What inquiry did you make about Mr. Calmbach?
I interviewed Mr. Calmbach.
Just briefly, what inquiry did you interviewed him?
Yes, sir.
All right. And you taped his conversation?
No, sir. I made this memorandum afterward, which I've given to the staff.
All right.
And in that, I think you will see that it's my conclusion that he acted in the best of faith, thinking that he was simply engaged in raising money for the defense fund purposes that he's testified to.
All right. Then, how many interviews did you conduct as a result of your being commissioned by the President to go into this?
Well, let me refer to my list again. Ten.
10.
Yes, sir.
How long did it take you to conduct these interviews?
Well, I did this in the period between the 5th of April and the 14th of April.
All right. Now, the President indicated that he had also assigned...
I'm sorry, Senator, the 15th of April. I beg your pardon. Because I saw Mr. Strawn at 9 o'clock Sunday morning, the 15th.
All right. Now, what was this statement of the President all about when he stated that on March the 21st, as a result of serious charges which came to my attention, some of which were publicly reported, I began intensive new inquiries into this whole matter? Now, what did he mean by that?
Well, I think what he meant by that was the series of events starting March 21st and culminating April 17th, which would have been his conversation with Mr. Dean on the 21st, the McCord letter to Judge Sirica on, the 23rd or whatever it was, his sending Mr. Dean to Camp David to write out his statement, Mr. Dean's return without the statement, his turning the investigation over, taking it from Mr. Dean, his turning the inquiry over to me, my efforts to talk to witnesses through this time, the parallel efforts, and I don't mean to in any way diminish the efforts of the investigators in the Department of Justice and in the prosecutor's office who are doing an extraordinarily effective job right at this time. You see, when I talked to Mr. Magruder, for instance, he had already been to see the U.S. Attorney and told them everything as a result of their efforts. So these were all parallel efforts going on, and there was a lot of reporting. The President had his meeting with the Attorney General and Mr. Peterson on that Sunday, and they compared notes as to all of these investigations, and then this all came to a head on that following Tuesday.
Then would you say that up until March, you were convinced, and the President was convinced at the White House, that there was no White House involvement?
Yes, sir.
You were convinced up to that time?
Yes, sir, and I was saying that all across the country because I believed it.
And you kept saying this to the President on the basis of information which you were receiving from Mr. Dean and others?
In the best of faith, yes, sir.
All right. Then why on January the 3rd were you so concerned that Mr. Hunt might blackmail the White House?
Why was I so concerned?
Yes.
Well, any time that somebody levels a blackmail threat against, well, no, excuse me, that happened March 20th. That did not happen January 3rd.
No, didn't you meet on January the 3rd with respect to the Hunt letter?
Oh, but that was not blackmail.
Well, he was asking for help.
Yes, but he was not making any threats that I knew of.
Well, I believe the testimony which has been adduced here indicated that Mr. Hunt was getting kind of nervous, that Mr. Parkinson imparted this information, which he received from Mr. Bittman to Mr. Mitchell, and Mr. Mitchell in turn imparted it to the White House, and then this conference was convoked where you, Mr. Dean, Mr. Colson, and others were present about the Hunt letter.
I'm sorry, Senator, I don't think that's the way that meeting came about.
All right, tell me how it came about.
My understanding is that Mr. Hunt had written a letter to Mr. Colson, and I recall seeing the letter, and that plus a telephone call from either Mr. Hunt or Mr. Bittman, and I don't remember which, to Mr. Colson's office, precipitated the meeting.
Well, why would you...
There's a vote on in the Senate, and we'll have to recess.
In a moment, Senator Montoya will have some comments about a conflict in evidence. Public television's coverage of the Senate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. NPAC continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
As the hearings resume, Senator Montoya is wrapping up. At that point, Senator Weicker has some questions about the political espionage done by Tony Ulazowicz.
Committee will come to order. Yeah. I just knew mine, and I thought myself, I had more information to give anybody on any subject, any meeting I've had with anybody today. Yes.
Mr. Ehrlichman, I believe the last question I asked you was, why was there so much concern around the White House about clemency for Mr. Hunt on January 3rd, in view of the fact that you have testified that up to that time you were all convinced there was no White House involvement?
Well, if I could first take the assumptions of your question, Senator, I can't agree that there was so much concern around the White House for clemency for Mr. Hunt. The fact is
well,
that
why did you have this conference?
We had the conference because Mr. Colson had a very strong concern about Mr. Hunt and his melancholy and his frame of mind and his letter which said that Mr. Colson in effect had abandoned his friend, and Mr. Colson was moved by this. It was the occasion for a meeting about what kind of a contact Mr. Colson might make with Mr. Hunt to reassure him on a personal basis. The purpose of the meeting was Mr. Colson's strong desire to make a response to that letter, which was a very compelling letter. I believe it's in your exhibits. So that's how the meeting originated.
Well, Mr. Colson testified about this meeting in the context of Mr. Hunt being very concerned and that he might blow the lid off and indicate something which would be unsavory to the White House.
Mr. Colson said that?
I believe he did, or someone else in the testimony of these hearings.
Mr. Colson hasn't been here yet, Senator. It
No,
must
no,
have
I
been
don't mean
somewhere else.
no, I don't mean Mr. Colson, Mr. Magruder.
Oh, Mr. Magruder wasn't there.
All right. Now, there was talk about clemency for some of the defendants at the White House, was there not?
At that meeting, there was talk about it, and the talk was that under no circumstances should it be offered, nor should it even be discussed.
Did you communicate this to Mr. Colson?
Yes, sir.
Were you aware that Mr. Caulfield had communicated an offer of clemency to Mr. McCord?
At that time?
No, I believe that was right after January the 3rd.
Oh, you mean at some other time? Did I
Yes.
become aware of it?
Yes.
I heard of it quite a long time after it happened. Yes, sir. And I heard of it during my inquiry, during the interviews of some of these people.
Did Mr. Caulfield ever communicate to you that pursuant to word from Mr. Dean, he had communicated an offer of clemency to Mr. McCord?
No, sir.
But now, I will go into another matter. I believe you have testified here that when the President authorized an investigation of the Ellsberg matter, that he talked to Mr. Krogh, and that in that discussion there was no contemplation that a burglary should be committed.
It was never discussed.
All right. And I believe you also stated that you were unaware that Mr. Krogh or anyone else had given the authority, but your testimony was that you assumed that Mr. Krogh had given permission to go into the Ellsberg psychiatrist's office. You assumed.
Yes, sir.
I think that was your testimony.
That's correct.
All right. Now, let us go into the statute, which is 1825:11, subparagraph 3. I believe that you and your attorney have tried to justify this as a legal venture and not a burglary because of this subparagraph 3, which gives to the President implied powers over the security of our nation. Now, if this particular thing or provision contemplates that the President take such measures in order for them to be valid, if your interpretation is correct, the President did not take any measure to give authority. Mr. Krogh, as you have testified, you just assumed that he had authority, but you're not sure that he did, and therefore there was no authority imparted from the only person that could give that authority for the commission of this burglary. And therefore, wouldn't you say that it was not a legal venture in promotion of the internal security of this country?
Well, Senator, my assumption was not with regard to whether Mr. Krogh had authority. My assumption was with regard to whether he had authorized the act by Mr. Hunt and Mr. Liddy.
Well, how could he authorize it if the President had not contemplated it when he gave the original charter for this investigation to Mr. Krogh?
Well, I suppose it's the difference between a general agency and what we used to call a special agency in law school.
But wouldn't you say that in view of the provision upon which you are relying, that specific authority from the only one who could give it, namely the President of the United States, was necessary in order to make it valid?
No, I would think that since we're talking about a constitutional rather than a statutory power, that a general delegation of capacity to Mr. Krogh would be required rather than some specific authorization of some specific act.
But this is not a statutory power. This is a recital of a reservoir of constitutional power in the President.
That's what I just said, Senator.
So in view of the fact that there was no specific authority, I'll ask you this question again, by the President, and in view of the fact that you are not sure whether Mr. Krogh had any authority to do so, and he certainly didn't under the wording of this, would you say that that burglary was legal?
Well, you're misstating what I understand about Mr. Krogh's authority. The thing that I said I had to assume was what passed between Mr. Krogh and Messrs. Hunt and Liddy, because I don't know. I do know what passed between the President and Mr. Krogh, and that was a delegation of very general authority on this subject. And in my opinion, that delegation of authority was very broad and very deep.
All right, now I might say to you, Mr. Ehrlichman, that your testimony has been contradicted by many of the witnesses who have appeared heretofore. And I believe that this committee has the task of judging your testimony against the testimony of others with respect to other matters of substance. And these other people are Mr. Dean, Mr. Mitchell, Mr. Magruder, Mr. Strawn, Mr. LaRue, Mr. Calmbach, and Mr. Sloan. I believe you have indicated in your testimony something contradictory of theirs in one manner or another, in one detail or another, and it is the duty of this committee to judge your testimony against this background and against all these threads of testimony offered by these individuals. And that's all I have to say, Mr. Chairman.
Well, I wouldn't want your remarks to go uncontradicted, Senator Montoya. I'm not aware of conflicts between my testimony and some of those that you read, number one. Number two, I understand the function of the committee to be legislative rather than adjudicatory. So I don't think that you're necessarily in the business of making findings of fact as to the testimony of specific witnesses. But passing that for the moment, it seems to me that whether there are conflicts in the evidence is not nearly as important as to whether or not conflicts in the evidence are supported, one side or the other, by corroborating independent evidence on material points. And I hope that you will find it possible, and the other members of the committee will find it possible, to examine the various extrinsic pieces of evidence, such as the letter from the CIA to the FBI and things of that kind, to determine which of conflicting testimony is entitled to the greater weight.
Well, I'm sure that we will do that. I personally will, I can assure you, Mr. Ehrlichman.
Thank you, Senator.
I'll weigh the weight of the testimony, and I will also give consideration to any documentary evidence that you present here, and certainly I think all the members will.
Good. Thank you.
Well, I think the prime function of this committee, one of the prime functions outside of making recommendations for legislation, is to find for the facts what the facts are, whether from testimony of witnesses or from documents. Senator Weicker.
Mr. Chairman, excuse me a moment. May this memorandum of April 6, which I passed to the chair, be included in the record at this point?
Yes, the reporter will mark it as exhibit and admitted as such.
Thank you, sir. Excuse me.
Mr. Chairman, I believe that a bell has just rung for a vote. This might be the proper time to go.
Well, we'll recess now and hurry back as fast as we can run.
The senators paused again for a vote on amendments to the Campaign Reform Act. As they come back to the hearing room, Senator Weicker has questions about campaign ethics, conflicts in John Mitchell's testimony, and possible CIA involvement in the cover-up.
Senator Weicker, you may examine the witness.
Now, Mr. Ehrlichman, I'm going to refer to your opening statement before the committee, and specifically I'm on page 11 of that opening statement. And in the bottom paragraph, you state that the council also has always had political duties. The president is the nation's chief executive, but he is also, by a long-standing tradition, his political party's leader. Any president has a political role to play, whether he's going to run for re-election or not. But if he's a candidate, then he is both an executive and a practicing politician. Every such politician wants information. And the president, in his politician role, is no different from the others. He needs and wants information about issues, supporters, opponents, and every other political subject known to man. For the years 69 to 70, when I left the post of counsel, I attempted to gather some purely political information for the president, as I was expected to do. Out of real concern for the proprieties, I attempted to use only conventional, non-governmental sources of information. As one might hire political aides in a political campaign, Tony Ulasewicz was hired to do this chore of information gathering. He was paid from existing Nixon political money by check under an appropriate employer's tax number. Among other assignments, he scouted the potential opposition for vulnerability. So far as I'm aware, during my tenure as counsel, Mr. Ulasewicz conducted his assignments legally and properly in all respects. Now I'd like to read to you from testimony given by Mr. Ulasewicz to this committee. Senator Weicker, now I'd like to, if I could, try to get into the general nature of the investigations, the other investigations which you conducted. Is it a fact that these investigations, or some of these investigations, were background checks on individuals intended to develop questionable facets of the personal lives of these individuals? Mr. Ulasewicz, that is correct, sir. Senator Weicker, now when we're talking about questionable facets, would this include sexual habits? Mr. Ulasewicz, these were allegations, and that might be included in the category, I guess. Senator Weicker, that would be included in the category. Drinking habits, Mr. Ulasewicz, yes, sir. Senator Weicker, domestic problems, Ulasewicz, yes, sir. Senator Weicker, personal social activities, Mr. Ulasewicz, yes, sir. And then finally, in concluding his testimony, whereby he characterizes his information gathering, Mr. Ulasewicz responded, Senator Weicker, I repeat my question. How would you categorize the information which you turned over to Mr. Caulfield? Mr. Ulasewicz, I would say it, Senator Weicker, was it of a national security nature? Mr. Ulasewicz, no, sir. Senator Weicker, domestic security nature? Mr. Ulasewicz, no, sir. Senator Weicker, dirt. Mr. Ulasewicz, no, it would be of a political nature. Senator Weicker, political dirt. Mr. Ulasewicz, all right, sir. Now, since in your opening statement you indicated that you were the one that was responsible when you were counsel to the President in turning over political information or information about issues, supporters, opponents, and every other political subject known to man. And since you were the one that hired Mr. Ulasewicz, I wonder if you might not comment to this committee as to the information which you turned over to the President, and again on the characterization that Mr. Ulasewicz gave his own job.
I don't know what period Mr. Ulasewicz was referring to in response to your question, Senator. I can only speak for the about 6 or 7 months that his tenure and mine overlapped. I think that the investigations which he did at the time that I was counsel in 1969 and the first month or two, 1970 perhaps, did not in any way relate to the political campaign of 1972. So I don't know whether this is in the scope of your inquiry or not, but just generally...
Well, I think it's very much in the scope of the inquiry on the election campaign of 72, and I believe, if I'm not mistaken, this covers the period after the 68 election up and through the 72 election.
Well, in any event, the one principal investigation that I recall, which Mr. Ulasewicz reported to me on, and I'm sorry that I don't have I don't think there were very many major ones of a political nature. My recollection is that a great deal of what he did had to do with Black Panthers and other violent group intelligence, and that's the other thing that stands out in my recollection. But Mr. Ulasewicz was sent to Edgartown to keep track of the development of the Chappaquiddick story. And it slips my mind as to just what the date of that was, but I do recall is keeping us informed on a regular basis of developments as they became available there.
And so that you transmitted this information to the President?
In summary, he produced almost nothing that wasn't a matter of newspaper reporting, as it turned out. So there was very little to pass on that would have been of any moment that you couldn't have read in an ordinary newspaper.
Well, of course, Mr. Ulasewicz testified that part of the information which he received was a matter of public record. Other information that he received was a matter of, or was received or gotten in an investigatory way. But why did you feel the necessity to have somebody like Mr. Ulasewicz investigate the Black Panthers? Is there some reason why possibly the law enforcement arm, is this another area that J. Edgar Hoover was weak on?
No, he had his connection with the New York Police Department at one point in time had been in intelligence involving violent groups of that kind. And he had sources, particularly in the New York Police Department Intelligence Division. And so he would be the recipient of information because of that former association.
Well, I know, but that still isn't a satisfactory answer. Was there some inadequacy on the part of normal law enforcement agencies?
Right. I previously testified, I think, Senator, that we were not getting an accumulation of intelligence from the police and the sheriff's offices and the state police of the various municipal and state organizations, and that it was some time, I think it was probably the second year or possibly into the third year, before there was set up in the Justice Department a facility for accumulating all of this. Mr. Ulasewicz, in the 6 or 7 months that he worked in the counsel's office when I was counsel, did a kind of a makeshift job of getting some of this information and feeding it in.
So the effect during this period of time is we all slept better at night knowing that Mr. Ulasewicz was on the job. Is that right?
Well, I don't know about that, Senator.
Well, I'm going to pursue this for a minute because let's get into the hiring of Mr. Ulasewicz. Was he brought down to the White House and interviewed for a job by the personnel at the White House? Just how was he
No.
hired?
He was hired because he was well known to Mr. Caulfield. Mr. Caulfield recommended him highly, and he was hired by me after a very brief meeting, but principally on Mr. Caulfield's say-so and recommendation.
Well, but where did you hire him?
Where did I hire him?
Right.
Well, I met him in an airport while I was on a trip to New York, as I recall, and Mr. Caulfield, as I recall it, arranged a meeting for us. I hired him, I guess, in the White House. That is, I made the decision and authorized Mr. Caulfield and made the arrangements with Mr. Calmbach to pay him.
Your first meeting with him was in the VIP lounge at LaGuardia Airport.
That was the only meeting I ever had.
That was the only meeting?
Yes, sir.
So that, is this some new situation whereby we're going to meet potential White House employees in the lounges of airports? Or?
Well, as I tried to say in my opening statement, he was not a White House employee.
I see. And
he was never held out to be. And as a matter of fact, the very point of having him was that we were not gathering political information with government people. Well, I didn't feel that we ought to have government people in that business, that we ought to have a fellow who was established on the outside, who was paid on the outside, and you have this anomaly of having to conduct some political activities, both of a fundraising and of a staff and of an investigatory nature. And you do it with political funds, and they have to be outside people.
Well, isn't it true? Now, certainly neither one of us is in the position of being a novice here politically. That the reason why you'd want him on an outside payroll would be that you wouldn't want to claim him if he were found out. Would that be a fair description?
Well, I don't think the way it was set up there'd be any way to disclaim him, Senator, because he was being paid very directly from Nixon campaign funds in the hands of a trustee committee, and there just was no way to disclaim him. There was no, everybody would be able to find out Mr. Ulasowicz's employer through just the employer number, if nothing else.
Well, I'll tell you, maybe everybody found out, maybe everybody knew, but we had to do an awful lot of digging around here to find out who Mr. Ulasowicz was and what role he had to go ahead and play. I'd like to have your concept, and I think this is very much, now we're getting into the real essence of the business of this committee. What is your concept of political information? You see, unfortunately, thanks to the committee to re-elect the president and some of the witnesses that have appeared here, everybody thinks that the senators at this table and others engaged in politics go running around hiring Ulasowicz types to dig up dirt on each other. And I just can't allow that to fly without contesting it, because really it's going to make elections rather interesting in the future if it does. And I wonder if you might, since you were the one that was responsible for hiring this man, and since we've had a description of by this man of exactly what his job consisted of, which was dirt, I wonder if you might tell the committee what your concept is of politics here in the United States insofar as this type of activity is concerned.
Well, I think that certainly there is room for improvement in the practice of politics in this country. There's no argument about that. But at the same time, I think that each candidate who contests the candidacy of an incumbent has the obligation to come forward and contest the fitness of that incumbent for office, both in terms of his voting record and in terms of his probity and in terms of his morals, if you please, and any other fact that is important or germane to the voters of his district or state, or the country for that matter. I think a candidate for office assumes that burden of proof. He assumes the burden of proof of showing the unfitness of the incumbent. And I don't think that in our political system that is limited to his voting record or his absenteeism. If it were, we would countenance the perpetuation of scoundrels in office who were thieves or who were fraudulent or who were profligate or otherwise unfit for office. And so I think it's perfectly competent for a challenger to meet head-on the issue of the fitness of an incumbent.
Do you mean to tell me in this committee that you consider private investigators going into sexual habits, drinking habits, domestic problems, and personal social activities as a proper subject for investigation during the course of a political campaign?
Senator, I know of my own knowledge of incumbents in office who are not discharging their obligation to their constituents because of their drinking habits. And it distresses me very much. And there's a kind of an unwritten law in the media that that is not discussed. And so the constituents at home have no way of knowing that you can go over here in the gallery and watch a member totter onto the floor in a condition which of at least partial inebriation, which would preclude him from making any sort of a sober judgment on the issues that confront this country. Now, I think that is important for the American people to know, and if the only way that it can be brought out is through his opponent in a political campaign, then I think that opponent has an affirmative obligation to bring that forward.
Well, now this is getting very interesting. Again, we contrasted similar situations yesterday, and I'm just not going to let these things get laid out on the table without giving another side to the argument. I've had 8 election campaigns in 8 years, 6 against Democrats, 2 against Republicans. I suppose it would be considered self-serving to say that I've never done anything like that, so I won't. So I'll refer to my opponents. I know no Democratic opponent out of the 6 and no Republican opponent out of the 2 that has ever done what Mr. Ulasewicz was doing, or what you are, in effect, advocating here. Now, it seems to me that it's up to the constituency, whatever that constituency happens to be, to make a determination as to the fitness of the man or the woman that they go ahead and elect. But do you really want to bring the political system of the United States, of our campaigns, down to the level of what you're talking about right now?
Well, I conceive of it this way, Senator. I know that in your situation, your lifestyle is undoubtedly impeccable, and there wouldn't be anything at issue like that. At the same
I'm
time,
no angel. I'm no angel, but I'll tell you,
I thought you were.
Believe me, I'm not. And I worry about you sicking people on the landscape here. I've probably got a greater worry now that I've heard about this than I did before I started it. I'll put it that way.
Well, I think you'll agree with me, Senator, that certainly someone with a serious drinking habit is of doubtful fitness for the kind of heavy duties that you bear, for instance, or that any senator bears in the Senate of the United States. That is certainly a material question that has to be raised in a political campaign, at least so it seems to me. Now, if that is not something that the incumbent's opponent should bring out, then you are leaving the constituency to the tender mercies of the journalists in the community as to whether or not that's reported to the constituency, because they don't have any way of knowing, really, especially the constituencies remote from here, where people get here very seldom to make an observation. So I would be very concerned about that, and that seems to me to be a very legitimate subject of inquiry. Now, maybe my standards are all haywire, and that everybody in the Congress ought to be immune from scrutiny on that subject. But that just seems to me to be an indefensible position on your part.
You think that we have no scrutiny around here?
Sir?
You think we have no scrutiny
well,
around here?
in all candor...
let's count them. They're all over here at this stage of the game, and they're here all the time, not just to hear you and I talk. If there's anything that is quite obvious in Washington, D.C. It's that every aspect of our lives, legislatively, personally, in every way, is subject to the scrutiny of a free press and subject to the scrutiny, at least the Congress is subject to the scrutiny of a free press.
Senator,
and also subject to the scrutiny of our constituencies. Our wives, right. I want to state right now, and obviously you and I are at loggerheads on a very basic issue here, and one that I think not only relates to Mr. Ulasewicz' activities. I'm not so sure we don't come right back to the break-in in Daniel Ellsberg's office again, that I am quite satisfied that our systems, our institutions, are perfectly capable of passing decent judgments, fair judgments, hard judgments on political figures, public officials, without the covert operations of men like Mr. Ulasewicz.
Senator, I would only disagree with you by saying this much. I think that your assumptions with regard to the full reportage by the media of the personal conduct of people in public life gilds the lily unduly. Certainly, you members of this committee are being subjected to scrutiny by the television and by the writing press to a degree, and your conduct is being evaluated and measured in a way that seldom happens to a member of the United States Senate or the Congress of the United States. And I think it is possible for some members to exist in a sheltered situation for years and years and years here, and perpetuate themselves in office, so to speak, because you know and I know that the advantages are heavily in favor of the incumbent. You are in a position to favor reporters with stories and so on. It's an uphill struggle for someone to take on an incumbent United States senator under any circumstances, and the press are not always as tough on others as they might be on the members of this committee in this setting. So I think you and I have a difference of opinion, but I think that reasonable minds can differ on this subject, particularly in the area of drinking, the area of fitness of that kind to discharge the duties. Now, certainly there are limits, and I would be the first to agree with you that there are areas where of subject matter that would be totally offensive to me as they would be to you. And I don't mean for a minute to contend for matters beyond those limits. But I do think that that's one of the things that this whole proceeding is about, I think, is an attempt to try and define the lines within which an inquiry as to an incumbent, his life, his performance, his voting record, are subject of proper inquiry.
Yeah, but I mean, if this is a matter of proper inquiry in the course of an election campaign, I mean, why isn't it a proper inquiry as far as all members of Congress are concerned, insofar as the relationship between the executive and the branch and the legislative branch? Why not? Is this material, in other words, that's going to be used as between the executive and the legislative branches of government?
I don't think I understand.
Well, you apparently consider it proper information to dig out to go ahead and win an election. Is it proper information to dig out to go ahead and carry an issue?
You mean blackmail? No, I don't.
I mean as between the legislative and the executive branches of government.
You mean, in other words, you have a piece of information and you
Right.
go to a congressman and say,
Right.
Congressman, we need... No, I don't think that's proper.
But it's proper in an election campaign.
I think it is proper to provide legitimate facts to an electorate that bear on the fitness of an incumbent.
Well, of course, what you're saying and where we disagree, and I want to make this clear, Mr. Chairman, if any other member of the committee wants to comment now, I don't think anybody realizes what's being done here right now. You definitely have two different concepts of politics in this country meeting head on.
I might say, Senator, that
Let me finish, and then I'll be glad to go ahead and listen to you.
Sure.
I always thought that we settle these matters on the basis of issues, on what you stood for, on a public stance that your opponent took that was a bad stance, how you can present yourself, how you move around and campaign. But to sit here at this moment in time and tell me that we're going to settle our elections on the basis of sexual habits and drinking habits and domestic problems and personal social activities, well, I'll tell you, you stick to your version and I'm going to stick to mine.
Senator, I was going to say that in what we have asked the FBI to do, to determine the fitness of an individual for appointment to the executive branch, to the cabinet, the sub-cabinet, to the agency positions and so on, these kinds of questions of fitness, drinking habits, habitual intoxication, immorality, are all considered to be important questions to ask and to settle upon. And the review, as far as I know, in the selection of people in this administration has been very rigorous, and the standards have been very high.
Well, number one, please don't put the FBI in the same category as Mr. Ulasewicz. Now, I just don't think that's a fair comparison at all. I think these are two entirely different entities. I am proud of the Federal Bureau of Investigation.
The subjects are the same, Senator.
I might add, you keep on talking about the enormous advantage that an incumbent enjoys. May I point out that according to your theory, the president was the incumbent.
Oh,
He was the incumbent.
Please don't misunderstand me. I think an incumbent president has an enormous advantage.
Yeah, but this one not only had an enormous advantage, apparently he went around and had this type of information handed to him, which added to the advantage that he had. I would say made him rather unbeatable. Well, in any event, let's leave that subject for the time being, although I find that unbelievable. Yeah. Yesterday, in response to a series of questions concerning the need for the plumbers, you stated as follows, and I assure you that the decision that was made in this matter to put investigators in the field was taken most reluctantly and for genuine purposes. And the purposes are simply to supplement what was considered to be an inadequate effort at the time by the Federal Bureau of Investigation. Now, in order to satisfy yourself on this, you ought to hear from Mr. Mitchell. That was your response. You will find that, incidentally, Counselor, you have the transcript on page 5535 of yesterday's testimony. Now, in order for you to satisfy yourself on this, you ought to hear from Mr. Mitchell. Well, now, we have already heard from Mr. Mitchell, and he testified before this committee that the first that he had heard of the White House horrors, the plumber's operation, was on June 21, 1972. This was after he had left as Attorney General. Is Mr. Mitchell lying?
As I said in my testimony the other day, Senator, Mr. Mitchell's recollection here is evidently hazy because the President authorized the creation of this unit on the 24th of July and asked that we meet with several members of the Cabinet who
24th of July, 71?
Yes, sir. To meet with several members of the Cabinet whose departments would be the subject of the special unit's stimulation, so to speak, to get them to perform better in this area of leaks. On the 28th of July, we had that meeting with Mr. Mitchell, at which Mr. Young, Mr. Krogh, and I briefed Mr. Mitchell on the President's desires, on the purpose of the special unit, and what it would be doing.
On what date was this?
July 28th.
1971?
Yes, sir.
So that when Mr. Mitchell said that the first he learned of the White House horrors was on June 21, there's been some debate, it might have been June 20th, 1972, that was inaccurate. Is that
yes,
correct?
sir.
Answer's that. Now, I'm going to follow through some dates and times with you, Mr. Ehrlichman. On the 20th or 21st of June, 1972, Mr. Mitchell, according to his testimony, learned for the first time, which you've just indicated was not true, but I'll follow through. According to his testimony, learned for the first time the Ellsberg break-in and other activities of the plumbers, which he called the White House horrors. And Mr. Mitchell was shocked by these revelations and feared that disclosure of these events might cost the president the election. That's what he testified to in front of this committee. Now, the next day, June 22nd, 1972, at your office, I beg your pardon, the next day, Mr. Mitchell met with you at your office at 11:45 a.m. Do you have that on your log?
Yes, sir.
Which meeting followed a group meeting he had attended with you at 9 o'clock?
Right.
And which meeting followed a phone call between you and Mr. Mitchell at 11:20 a.m. That's on Mr. Mitchell's, according to Mr. Mitchell's logs. Phone call, in other words, he met with you at 9, or it was at a group meeting with you at 9 o'clock on the 22nd in the morning. Mr. Mitchell's logs show that he had a phone conversation with you at 11:20 on June the 22nd. And then at 11:45, he meets with you. Now, what did you and Mr. Mitchell discuss at your 11:45 a.m. meeting that you could not discuss either at 9 o'clock when you met with the group or at 11:20 on the phone?
I don't know, Senator. Does his log show whether he originated that phone call or I did? Because I cannot reconstruct that meeting. I just do not know what that meeting was about.
You mean the 11:45 meeting?
Yes, sir.
No. I have no
And it would depend, and it would help me to reconstruct, to know whether I had placed it, in which case probably the president had asked me to refer something to him, or whether he had placed it, but I just draw a blank on it, I'm sorry to say.
Do you think there's any possibility, considering the fact that Mr. Mitchell had received the report from Messrs. LaRue and Marty, either the day before or 2 days before, depending on which version you want, that he specifically discussed with you this problem of the break-in, the White House horrors, and his fear as to what it would do in the election?
I would suggest that it had not happened that way for this reason. I suspect that this meeting was convened for the reason contained in the phone call, whatever that was. And I'm sorry to say I don't know what it was. But had it been something that was in his mind in the morning when we all got together at 9:30 or 10, he most likely would have stayed back, as sometimes happened with some of those people in the meeting. From time to time, Clark McGregor, for instance, would stay back after everybody else left, and we would talk about something that he had on his mind. Now, I'm really surmising there. I just don't know. I can tell you this, that at no time did Mr. Mitchell express to me his concerns, which he described here to the committee, about the so-called horrors.
At no time?
I do not recall his ever doing so.
All right. On the same day, according to Mr. Gray's statement to this committee and General Walter's memo of June 28, 1972, Mr. Gray routinely inquired into the possible CIA involvement in the Watergate case and was told by Director Helms that there was no involvement. The next day, on June the 23rd, you and Mr. Haldeman called Mr. Helms and General Walters to a meeting in your office, which meeting General Walters characterized as follows. And I think it important to read this memorandum. Memorandum for the record. This is General Walters, 28 June 1972. On June 23rd at 1300 on request, I called with Director Helms on John Ehrlichman and Robert Haldeman in Ehrlichman's office at the White House. Haldeman said that the bugging affair at the Democratic National Committee headquarters at the Watergate Apartments had made a lot of noise, and the Democrats were trying to maximize it. The FBI had been called in and was investigating the matter. The investigation was leading to a lot of important people, and this could get worse. He asked what the connection with the agency was, and the director repeated that there was none. Haldeman said that the whole affair was getting embarrassing, and it was the president's wish that Walters call on acting FBI Director Pat Gray and suggest to him that since the 5 suspects had been arrested, that this should be sufficient, and that it was not advantageous to have the inquiry pushed, especially in Mexico, etc. May I stop here for 1 second? The reason for my reading this memorandum to you is that obviously there are 4 participants in this meeting, and I want each one to have a chance to go ahead and comment on it, and even though all of it doesn't apply to you, you are there, you're one of the participants at this meeting. Director Helms said that he had talked to Gray on the previous day and made it plain to him that the agency was not behind this matter, that it was not connected with it, and none of the suspects was working for nor had worked for the agency in the last 2 years. He had told Gray that none of his investigations was touching any covert projects of the agency, current or ongoing. Haldeman then stated that I could tell Gray that I had talked to the White House and suggested that the investigation not be pushed further. Gray would be receptive as he was looking for guidance in the matter. The director repeated that the agency was unconnected with the matter. I then agreed to talk to Gray as directed. Ehrlichman implied I could do that. It looks like I should. I don't want to say something that's incorrect there.
That's right.
I should do this soon, and I'll get a clean copy. And I said I would try to do it today. On leaving the White House, I discussed the matter briefly with the director. On returning to the office, I called Gray, indicated this was a matter of some urgency, and he agreed to see me at 14:30 that day. Now, that's General Walters. Mr. Helms stated to this committee during an interview as follows. A few minutes later, Haldeman and Ehrlichman walked in, and Haldeman, in no uncertain terms, instructed Walters to see Pat Gray at the FBI and instruct him not to pursue his investigation in Mexico concerning Ogerio and Dahlberg, since it might involve the CIA. Helms had no idea what they were talking about with respect to Mexico, and when he asked, was told, never mind what it's all about, but they wanted Walters to go to Pat Gray right then and there. End of quote in the interview with Mr. Helms. Now, isn't it a fact that the meeting with Director Helms and General Walters on June 23rd was an effort to hinder the Watergate investigation?
Senator, that meeting was convened at the President's request. I learned later that the President was operating on the basis of an independent source of information and out of a concern that an all-out FBI investigation might compromise some CIA activity. My recollection of that meeting is at considerable variance with General Walters in the general thrust and in the details. In point of fact, as I recall it, we informed Mr. Helms and General Walters that the meeting was being held at the President's request for the reasons that I just stated. Mr. Haldeman said that the Watergate was an obvious, important political issue, and that the President had no alternative but to order a full, all-out FBI investigation unless he was satisfied that there was some specific area in which the FBI should not probe for fear of leaks through the FBI of disassociated and disconnected CIA activities that had no bearing on Watergate. As I recall, there were a couple of basic questions that were asked of these gentlemen. One was whether the CIA was directly involved in the break-in itself, and they said it was not. The other was whether or not there were any disassociated CIA activities, past or present, which might somehow be disclosed through a vigorous FBI investigation. They did not make the same kind of a categorical negative response to that question as they had made to the other. As a matter of fact, my recollection is a response to the effect that they don't keep track, that is the director and the deputy director, of these regional activities, such as the one in Mexico. They would want to check with a regional man. Now, you have in your...
But they'd done that.
Sir?
They had done that.
No, I think their letter of the 6th of July to the acting director of the Federal Bureau of Investigation shows that they had not done that. And they did not do that, and they did not assure the FBI until the 27th of June as to the Mexican situation. And then they confirmed that oral assurance of the 27th of June in writing on the 6th of July, and on the 6th of July is when Director Gray called the President and said, "I now have a memo from the CIA assuring me that there is no problem," and the President said, "Let's go all out." So that is the sequence of events.
Why did the director call the President?
Because he received, I assume it's because he had this memorandum.
Oh, no. Oh, no. Why did the director call the President?
Point of fact, I think the President called the director.
That's correct. The director had called Mr. McGregor.
That's true.
And he had expressed to Mr. McGregor doubts as to this situation. He felt this was the best way to go ahead and get in touch with the President. The President called him back shortly thereafter.
Well, I wasn't at the meeting between Mr. Gray and Mr. McGregor, so I don't know what they said, but I do know that the President told me that Mr. McGregor said to him when he came and called on the President on the 6th of July that he had been talking to Pat Gray and that Pat Gray felt it was important that he talk with the President right away, and the President picked up the phone immediately and called him.
And did Pat Gray tell the President of his fears that there were those around him that were trying to wound him?
I had never heard that.
Is it not a fact that General Walters and Pat Gray both felt it was necessary to call the President on this matter? That both of them had the same apprehensions that the investigation was being interfered with?
I think it was important for Pat Gray to have talked with the President, too. I heartily concurred with that. I hope you understand that when Mr. Haldeman and I met with the CIA, it was for the purpose only of conveying to those gentlemen the President's concern, and the meeting did not culminate in any instructions to anyone except a request to General Walters that he sit down and talk to Pat Gray about this matter and reassure Pat Gray if he could be factually reassured. Now, that in fact is what happened, and Mr. Haldeman and I disconnected from this after that one 20-minute meeting.
All right, let's drop back in time again here to the meeting on June 23rd. You're sitting here with the director of the CIA and with General Walters. Now, wouldn't it be logical to address any request of the CIA to the director of the CIA?
Not if you were told by the President that he wanted to work through General Walters.
Now, let me repeat Mr. Helms's testimony, or his interview, with this committee. Helms had no idea what they were talking about with respect to Mexico, and when he asked, was told, never mind what it's all about. But they wanted Walters to go to Pat Gray right then and there.
The President's instructions were not to me, they were to Mr. Haldeman, and he's going to be your best witness as to those instructions. But my understanding of those instructions secondhand is that the President said that he wanted General Walters and Pat Gray to work this out between them. And that was confirmed to me by the President at a later time, but I didn't know it at the time of this meeting.
And then we also have General Walters' memorandum, which I've read to you, in which he indicates concern over the Watergate investigation in a political sense. And you disagree with that?
The memorandum that you read to me was dated the
do you have a copy of that memorandum?
28th of June, which was considerably
5 days after.
And as a matter of fact, after the CIA finally determined that it had no involvement or exposure on the 27th and orally informed the Bureau to that effect. It was then and only then that General Walters sat down and reconstructed these meetings.
So, in effect, your testimony stands in conflict with the versions of that meeting told by, as I've read them to you, of both General Walters and Director Helms.
Yes, sir.
Now we're getting somewhere. One last series of questions, Mr. Chairman, then I'll move along here. I'd like to, if we could, get to the taped telephone conversations, the conversations which you taped. Do you have both those before you?
Which are those,
These
Senator?
would be the two. I find it strange in the United States when we say, which are those, as if this were the normal practice. These are the conversations with Pat Gray on March 7th or 8th, and the follow-up conversation with John Dean the same day, whatever day that happens to be. You have those? And I wonder if at this time, if we might not, Mr. Chairman, have these entered as exhibits.
What does you want entered as exhibits? I didn't quite get what you wanted entered as exhibits.
The transcriptions of the two taped telephone conversations, the first between Mr. Ehrlichman and Pat Gray, the second one between Mr. Ehrlichman and John Dean.
Did Mr. Ehrlichman identify the one that he was a party to?
He was party to both, Mr. Chairman.
He's the two papers will be marked exhibit and admitted as such. I'm sorry, I thought maybe you were referring to the General Walters matter.
As the committee sorts out the transcripts of all those telephone calls, we're going to take a short break. Public television's coverage of the Senate Watergate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. Activities. Here again, correspondent Jim Lehrer.
As we go back to the hearings, Senator Weicker is asking Mr. Ehrlichman about hearings on Patrick Gray's nomination as FBI director.
All right, let's get first to the conversation between yourself and Pat Gray. The first portion of it, let me try to synopsize that. Gray makes some preliminary unless you want the whole thing read. If you want the whole thing read, we can do that. Would that be better to handle it that way so that there won't be any unfair...
No, why don't you just ask whatever you have on your mind, Senator, and then see if I can answer.
Well, Pat Gray makes some preliminary remarks concerning his position that the judiciary... These are phone conversations, March 7th or 8th, 1973, when Pat Gray is before the Judiciary Committee, subject of his confirmation. Gray made some preliminary remarks concerning his position that the Judiciary Committee could only question his procedural conduct in the investigation, not the substance, since the Irvin Committee would do that. He also pointed out that the very same day the ACLU submitted a letter to the committee stating the same position. Gray then went on to say, quote, and now I'm going into the exact quote, and this is Gray to Ehrlichman. The thing I want to talk to you about is that I'm being pushed awfully hard in certain areas, and I'm not giving an inch. And you know those areas. And I think you've got to tell John Wesley to stand very tight in the saddle and be very careful about what he says and to be absolutely certain that he knows in his own mind that he delivered everything he had to the FBI and doesn't make any distinction between, and then something goes on, it's inaudible, but that he delivered everything to the FBI. Now, what did you assume this to mean? What's he talking about here when he says, and you know those areas? And I
assumed he was talking about the method of delivery of the contents of Hunt's safe, the fact that some went to the Washington field office and some went to the director directly.
Ehrlichman. Right. Gray. And that he delivered it to those agents. This is absolutely imperative. Ehrlichman. All right. Gray. You know, I've got a couple of areas up there that I'm hitting hard, and I'm just taking them on the attack. Ehrlichman. Okay. Gray, I wanted you to know that. Ehrlichman. Good. Keep up the good work, my boy. Let me know if I can help. Gray. All right. He can help by doing that. Ehrlichman. Good. I'll do it. You then immediately called Mr. Dean. Is that correct?
Yes, sir.
And I'd like to go ahead, if we could, and read this conversation. Dean, hello. Ehrlichman. Hi, I just had a call from your favorite witness. Dean, which is? Ehrlichman. Patrick J. Gray. Dean, oh really? Ehrlichman. And he says to make sure that old John W. Dean stays very, very firm and steady on his story that he delivered every document to the FBI, and that he does not start making nice distinctions between agents and directors. Dean, he's a little worried, is he? Ehrlichman, well, he just doesn't want there to be any question. He says he's hanging very firm, and there's a lot of probing around. Dean, yeah, he's really hanging tough. You ought to read the transcript. He makes me gag. Ehrlichman, really? Dean, oh, it's awful, John. Ehrlichman, why did he call me? To cover his tracks? Dean, yeah, sure. I laid this on him yesterday. Ehrlichman, oh, I see. Okay. Dean, I laid it on him to, to fuse the issue, so I don't have any idea what he said up there today. Ehrlichman, I see. It was a funny phone call. Said he's going in to object to the jurisdiction of the group to get into the substance, and that their only jurisdiction was to, and again, inaudible there, to procedural efforts and his competence, and he says the ACLU put a letter in to the same effect. Dean, yeah, Wally picked up an interesting one on the grapevine today. The planned strategy now is to proceed in this one as it did in Kleindienst. Ehrlichman, down to the point of calling you. Dean, down to the point of calling me. Ehrlichman, let him hang there. Well, I think we ought to let him hang there, let him twist slowly, slowly in the wind. Dean, that's right. And I was in with the boss this morning, and that is exactly where he was coming out. He said, I'm not sure Gray is smart enough to run the Bureau the way he's handling himself. Ehrlichman, well, okay, you're on top of it. Good. Now, Mr. Ehrlichman, first of all, that portion of the transcript, which the dean says, yeah, sure, I laid this on him yesterday, and you say, oh, I see, okay. What is being referred to there?
I don't know. I don't know and never did know, I don't think, what Mr. Dean had talked to him the previous day about. I was looking, as you were reading, to see if I could see what had been transpiring in that particular week in those hearings, and it seems to me that the issue was primarily whether Dean sat in on the interviews that the FBI conducted during the Watergate investigation, and the question of whether Dean would come to the Judiciary Committee and testify. I think that this was one of a series of telephone calls that Mr. Gray made to me and to Mr. Dean at the close of his testifying every day to give us his view of how things had gone for the day, sometimes rather optimistic. But in direct response to your question, I don't know to what that does refer. That is to say, what Mr. Dean talked to him about the previous day.
In other words, that would then go into the same area of, I laid it on him to, to fuse the issue. In other words, again, your response would be similar there as to you don't understand what he was talking about.
Well, that's correct, unless it refers back to this question of who the documents were delivered to. If it refers to some other subject, I don't know.
Well, let me ask you a question. Yesterday, you testified to two separate events. One was the 15th of April, where Mr. Peterson and Attorney General Kleindienst informed the President, and I think you said yourself also, of the fact that the records, the Hunt records, had been burned by Pat Gray, and that precipitates the phone conversation.
No, sir. They had a conversation.
If I can say, that precipitates the phone conversation to Gray in the evening.
No. At the time of that telephone call in the evening, neither the President nor I knew or had any reason to believe that Mr. Gray had destroyed the documents.
Well, I think that it might be. Let me get back to that question in a minute. I'll get back to that question in just a minute. You also, let me drop back in time. At the beginning of April, you went out and you had a talk with Judge Byrne relative to the FBI directorship. Now, it's clear from this taped telephone conversation that you don't think very much of Mr. Gray, unless for some reason or other swinging around in the breeze is a new term of endearment that I don't know anything about. And obviously, from what John Dean says, the President doesn't think very much of Pat Gray. He says that, I'm not sure Gray is smart enough to run the Bureau the way he's handling himself. And obviously, Dean says, does he say he makes me gag. So John Dean doesn't think very much of Pat Gray. What in heaven's name is Pat Gray doing up there at these confirmation hearings as the nominee of the administration?
Well, Senator, I think you'll remember those confirmation hearings and the revelation of the manner in which Mr. Gray responded during the hearings. And I think it's fair to say that there was pretty general disenchantment with the manner in which he handled himself during that time. This is what I was looking at while you were reading, was the various events that took place starting back around the first of the month in those hearings and climaxing on the 23rd of March with Mr. Gray saying that John Dean probably lied to the FBI, and then later privately recanting that charge to Mr. Dean and admitting that it was an overstatement and so on. Now, at this point in time, there was general disenchantment with Mr. Gray's conduct in the process of confirmation. There's no question about it.
But do you mean to tell me if there's this degree of disenchantment that you're going to keep this man on as the nominee and then later on as acting director, in fact, until April the 27th, when in fact it's Pat Gray that steps down? Is that correct?
Well, I think
there must be some reason. There must be some reason.
I think the situation was evaluated as being perhaps doubtful and painful as it existed, but perhaps more painful to withdraw the problem. And so there was a weighing of the alternative evils, and it was felt on balance at some point in time along in there, and I've forgotten about where it was, but it must have been right about this time that nomination was essentially doomed, that it wasn't going anywhere in the committee, and that we had to set about finding some alternatives. And somewhere along in this period of time, the President begins active consideration of an alternative list.
But March 7th or 8th, obviously from the language that everybody uses here, you say the nomination is doomed. And yet nothing happens until April 27th, and only then, because at least a good portion of the Pat Gray story was made public on the 26th, 27th.
Well, Senator, the die was cast long before that. And as I explained to you yesterday, I believe, the only reason that the President forbore to remove Mr. Gray prior to that date was in cooperation with the Attorney General and the Assistant Attorney General, who had asked him to permit them an opportunity to complete their work.
Haven't even gotten to April 15th yet. On April 15th, apparently matters come to your attention which involve, specifically, Mr. Gray admitting that he destroyed the documents. So we can now add 10 more days onto the time when Pat Gray is kept in place. Do you think there's any possibility of the fact that either Pat Gray was kept in place so that there was an acting director of the FBI under the control of you and Mr. Haldeman, or that Pat Gray was kept in place so that he could be a part of the Monday night TV spectacular when you and Haldeman and Kleindienst
as you say, the President was fully advised of the facts on the 15th. As soon as he decided to move, he immediately replaced Mr. Gray with Mr. Ruckelshaus, who was one of the names that had been on this alternative list for some time. So that it was not a situation, I can't think of any particular advantage to anyone in that delay except to the investigators. And that is to say, Mr. Peterson and the Attorney General, who felt that they had to make their case.
On March 7th or 8th, in discussing Pat Gray, Dean says he makes me gag, you've got him hanging, and the President says he's not smart enough to run the Bureau. Now, this is an evaluation made of the director, the nominee for the directorship of the Federal Bureau of Investigation. This is the man that is supposed to serve us all. And these evaluations are made on the 7th or 8th of March, and nothing happens. And then on the 15th of April, the man even turns to you and says, burn the files. He admits it. And he's still held in place. And you're telling me that basically all that was involved here was, number one, an investigation after April 15th. What would be the reason for holding him in place between March 7th and April 15th?
Well, the decision was made to let the confirmation process run, and that ran until, let's see, first part of April, as I recall. The 6th of April.
Did the President ask for his resignation?
I think not. I believe that Mr. Gray submitted his resignation and informed the President.
If the information about Mr. Gray had not been made public, do you think he still would have submitted his resignation on the 27th of April?
Well, I have no idea as to the state of the investigation at that point. The President was working directly with the Attorney General on that and with Mr. Peterson. And I think they were calling the tune pretty well as to the timing.
Do you think the President would have asked for his resignation by the 30th?
I don't know, Senator. I haven't any idea.
I have no further questions, Mr. Chairman.
When was it that you phoned Henry Peterson, Assistant Vice President in charge of the Criminal Division of the Justice Department and the person having general supervision of the prosecution, and conveyed to him the President's request that Marsh Stans not be compelled to go before the grand jury?
I'm not sure, Mr. Chairman. I could search this log and see if I could...
Well, it was sometime considerably before September, wasn't it?
I would assume so.
Yes.
I believe I have that date in my log, but I cannot recall it offhand. I'll find it for you overnight if you'd like me to.
It was before the bills of indictment were returned by the grand jury in September 1972.
It was during the original grand jury process.
Now, you stated yesterday that some other witnesses were not required to go to the grand jury.
That's my understanding.
But you didn't make any phone calls about them.
No, sir.
I'm bound to say, just by way of observation, that your testimony that Morris Stans was excused from going before the grand jury pursuant to request made by the president. Under our system of criminal jurisdiction, witnesses are supposed to go before the grand jury so that the grand jury may ask them questions, even though there may be questions that the prosecuting attorneys do not see fit to ask. Now, the testimony of Morris Stans was taken in the Department of Justice in the absence of the grand jury and in the presence of the prosecuting attorneys. What that testimony was, the committee doesn't know, and it has no way of getting access to it. The Morris Stans was director of the Finance Committee to re-elect the president, and one can reasonably assume that he knew more about the finances involved than any other human being, or should have known more about them. If he had gone before the grand jury, one of the, I don't know whether it was a 16-man or a 23-man grand jury, but if he had gone before the grand jury, any one of those grand jurors who had an inquisitive mind could have ascertained by questioning Morris Stans what Morris Stans testified before this committee. And Morris Stans testified, at that time they were investigating the break-in of the Watergate. It was known that 5 burglars had been caught in the Watergate, red-handed, in an act of burglary in the headquarters of the Democratic National Committee. It was known that one of them, McCord, was the security officer of the committee to re-elect the president. It was known that the other 4 burglars had in their possession at the time they were caught campaign funds belonging to the Nixon campaign. A few days later, George Liddy, the chief counsel of the Finance Committee to re-elect the president, of which Stans was director, and E. Howard Hunt, who was on the White House payroll and who had an office in the White House and who had been associated in the Ellsberg matter with Liddy, were arrested and charged in effect with masterminding the burglary. Morris Stans testified that instead of depositing such monies in the bank, which would have made a documentary record of their receipts and disbursements possible, he had $1,700,000 kept in 2 safes in cash in the office of his committee. He testified that over $1 million of this money was disbursed in cash. He testified that his treasurer Hugh W. Hunt Jr., Hugh W. Sloan Jr., came to him and told him that he had grave misgivings about disbursing thousands of dollars in cash to Liddy on the orders of Jeb Stuart Magruder, the deputy director of the committee to re-elect the president, of which John Mitchell, former Attorney General, was director. He testified that pursuant to the misgivings expressed by him, to him by Sloan, he held a consultation with Mitchell. He testified that after he held this consultation with Mitchell, he had a consultation with Sloan. And he told Sloan that Mitchell said that he should go ahead and continue these disbursements, which Sloan said ultimately ran to $199,000 in cash to Liddy. He also stated when Sloan sort of reiterated his misgivings, that he said to Sloan, I don't know what this money is being used for. I don't want to know what this money is being used for, and you don't want to know either. Now, I'm not saying anything what the president's intention was. The president ought to have never made a request which had the effect of bypassing the judicial process by which witnesses in investigations go before grand juries and are subject to being questioned by grand juries. But as a result of the president's request, which you communicated to Peterson, and which Peterson and the prosecuting attorneys complied with, which they ought never to have done, the grand jury, which was trying to find whether any persons ought to be indicted and whether any persons had procured the seven defendants to break into the Watergate, were implicated. If Sloan had given this testimony, Stans had given this testimony to the grand jury he gave to this committee, it would have indicated that the evidential tracks led directly from the Watergate burglary into the office and to some of the high officials in charge of the committee to re-elect the president and the finance committee to re-elect the president. And as a result of the prosecuting attorneys giving Mr. Stans a privilege that no citizen of the United States was entitled to have, at the request of the president, the grand jury was deprived of the benefit of this testimony.
Mr. Chairman.
And only the 7 people originally arrested were indicted.
Mr. Chairman.
Yes.
Lest the viewers be left with the impression that the grand jury didn't see the deposition, I think it's important to note that the grand jury did in fact have that deposition read to them, and it included the questions of the prosecutors and Mr. Stans' response, as I understand it, and then, of course, the grand jury had the opportunity to indicate to the prosecutors any additional questions that they might wish to have asked of Mr. Stans, or, in point of fact, as counsel advises me, they could have asked that Mr. Stans then be brought to the grand jury.
But you don't know what was in the deposition, do you?
Sir?
You don't know what was in
I just...
And you were not in the grand jury room.
I think you're leaving the impression, Mr. Chairman, that the deposition was somehow or another kept away from the grand jury.
Yes, but the deposition's been kept away from this committee. And I know from trying to extract testimony from Mr. Stans that you had to pull testimony out of him. You had to get questions as strong as a 2-team oxen.
Are you suggesting that his testimony before the grand jury would have been available to this committee, Mr. Chairman?
No, I'm not. That's exactly what I'm talking about. But the grand jury would have heard would have seen Mr. Stans in person, and the grand jury could have asked him the questions if they weren't satisfied with what the attorneys were asking. And instead of letting him go and be seen and heard by the grand jury, they treat him like no American citizen was entitled to be treated. They took his testimony secretly, with nobody present except perhaps a reporter and the prosecuting attorneys. And this committee can't find out what Stan said before the grand jury. And you don't know, and I don't know, but this is a kind of a situation that makes people grieve over justice being so treated, even at the request of the President of the United States.
Mr. Chairman, I have no quarrel with your major thesis that it's an extraordinary and unusual situation for one to give testimony for grand jury purposes by deposition instead of personally. But I would make only one collateral point, and this is not said in defense of anyone. It's simply an observation. Had Mr. Stans testified before the grand jury in person, this committee would not have had that testimony either. The important thing, the point that you make, and with which I fully agree, is that the grand jury system did not function in the prescribed way. The grand jury did not have face-to-face confrontation. It was unique and it was different. But for fear the image may be left that we were, as a committee, deprived of that testimony, a grand jury's deliberations are, and they ought to be, inviolate. And they would not have been available to this committee in any event.
My point is this, that if the grand jury had had the testimony which Mr. Stans gave here in person, they might well have concluded that there was a prima facie case that officials of the committee to re-elect the president had hired these 7 men to burglarize the Watergate, and by reason thereof they might have indicted them for being accessories before the fact to a murder. They didn't have the benefit of the testimony of Mr. Stans' evidence in person.
Mr. Chairman, did the chairman say murder? I think you meant burglary.
Burglary.
There's a new surprise every day, but I wasn't prepared for that one. So.
Well,
May I answer that?
no, sir. No, I don't think it. I don't think it that you're not defending anybody except Mr. Ehrlichman.
Well, this would
And
be
you're not a witness, Mr. Wilson.
This would be defending Mr. Ehrlichman against that remark.
Well, you are not a witness, Mr. Ehrlichman. I mean, Mr. Wilson.
But you say I'm here defending Mr. Ehrlichman.
Yes, you're here to defend Mr. Ehrlichman.
I can make a pertinent answer to what you just said. May I make it?
Our rules don't entirely to, but if you can explain why Mr. Stans ought to be treated in a different way from any other citizen in the United States, when there's no law that allows it, I'd be glad to hear your explanation.
How do you know that Mr. Stans' deposition that went to the grand jury is any different from his testimony before this committee?
I don't know, because there's no way to tell it. But I know that if he had testified before that committee, before the grand jury, and given the same evidence he gave before this committee, the grand jury would have had a reasonable basis for reaching the conclusion that there was a prima facie case, and that's all the grand jury's got to find, that officers of the committee to re-elect the president had procured this burglary, and they could have presented them for indictment as accessories before the fact to burglary. Because the evidence is that the money came right out of the committee to re-elect the president and right to these people. The committee will stand in recess till 10 o'clock Monday. Very
John Ehrlichman apparently has still more to say, and the committee obviously has more questions, so he'll return Monday morning when the hearings resume. Ehrlichman has not been the most talkative witness the committee has heard, but several senators apparently find him the one who inspires the most fear, with his view of presidential power as all but limitless. Perhaps, as some have suggested, this is nothing but a tactic designed to distract the committee from examining the specifics of the Watergate break-in or cover-up. Still, Ehrlichman's comments on those points have served as a confirmation for many students of presidential power who saw a White House role growing at the expense of other branches of government.
The Ehrlichman testimony may set a new record for the committee in terms of longevity, outlasting even that of former presidential counsel John Dean. Peter Kay has a report on what that means to the committee's timetable.
The length of Ehrlichman's testimony means that the committee may have to abandon plans to recess on August 3rd. Several senators, including Senators Talmadge, Weicker, and Gurney, indicate they might like to skip the recess altogether and go plowing right through August. But there are other opinions, and one of them I got from Rufus Edmiston, the Deputy Chief Counsel.
Now, obviously, Mr. Ehrlichman will come back on Monday, and I assume we'll finish him Monday. But I must say I have heard the chairman and the vice chairman on 3 or 4 occasions today say that the committee was going to go home for a while on August the 3rd. And, you know, I normally believe what Senator Ervin says. Now, things may occur that we will not be able to leave, but I'm simply saying that I know that the chairman and the vice chairman say that they are very anxious to go on the 3rd, and I can't go into who we will not hear and other matters like that, but, you know, we can come back, and we can come back earlier than the Senate will come back. But so I'm making the bet that we will go home on the 3rd. Now, any takers, I'll be happy.
Another casualty of the lengthy testimony is the Watergate Committee staff, and on top of all its other troubles, it has to prepare the committee's case against the White House. This may go to court on the part of the committee next week, possibly as early as Monday.
Until today, there had been much criticism of the committee's questioning of John Ehrlichman, but it changed today, according to our 2 observer experts at least who watched it with us, Jack Murphy of the Georgetown University Law Center and Clark Molinoff, Pulitzer Prize-winning investigative reporter of the Des Moines Register-Tribune, syndicated columnist and former special consultant to President Nixon. First, Mr. Murphy, how did the questioning get better in your opinion?
Well, it was much sharper, Jim. We had, after 3 or 4 days now, of rather general analysis of the constitutional powers of the respective branches of government and issues of national security, some very hard questioning about detailed involvement of Mr. Ehrlichman in the critical meetings in June of 1972, January of 1973, March of 73, and April of 73. I was particularly intrigued that Senator Gurney was the one who broke through the miasma of generalities in which we, forgive me, wallowed all this week, and brought us back home to the critical details with which this case should be concerned. The effort of Senator Weicker, after something of a false start on general concepts of politics in this country, to produce information from Mr. Ehrlichman on the involvement of the CIA and especially of that critical meeting on June 23rd of 1972 between General Walters, Mr. Helms, and Mr. Haldeman and Mr. Ehrlichman seemed to me just fascinating beyond question and casting real light on that particular period. I will be very intrigued to see what follow-up there will be in particular on that CIA question.
Clark, do you agree that today, at least, there was some focus on the conflicts between witnesses, how Ehrlichman's testimony differed with others?
Today, I think the committee zeroed in. Even Senator Montoya was able to zero in on the conflicts, and he pointed up the specific conflicts of about 7 or 8 witnesses with Ehrlichman, and this would have ranged all the way from Dean all the way through Mitchell, Strawn, and others. But I think the most important thing today was the use of the tapes of conversations which Ehrlichman apparently obtained or took when he was thinking he was protecting himself. And they came back to haunt him today. The last time I saw anything like this was when Jimmy Hoffa, back in 1957, was rocked by the DioGuardia tapes in New York City, and where they were playing back his conversations. Today, Ehrlichman found himself faced with his own words and forced to try to make explanations of his conversations with Dean, where he was more of a co-conspirator than an aggressive investigator of the Watergate cover-up.
Of course, he knew they were coming because he had done the taping and had given the transcripts to the committee.
But he was caught with his own words, and he would have rewritten those words a great deal, and it was apparent all the way through. But today, I thought the most significant thing was Senator Ervin's pressing to get the admission from Ehrlichman that President Nixon was the one who had actually requested that he call the Justice Department to make these special arrangements for Maurice Stans to testify at the Justice Department away from the federal grand jury and to let it pass as if he'd been before the grand jury. Because, as Senator Ervin pointed out, the material that Stans testified to before the committee, if it had been before the grand jury last fall, would have made a prima facie case to uncover the whole cover-up at that stage, because Stans was knowledgeable about all of the financial details, the questionable activity by Magruder, the conflicts between Magruder and Sloan, and a wide range of other things. And Senator Ervin pointed this up as the hearing came to a close in the most magnificent, dramatic fashion.
And don't you think, Clark, that it's well to point out that the reason that it's important to question about these various events, like the Stans request, like the CIA meetings, is that all of this adds up to what has commonly been referred to as the cover-up. Now we have Ehrlichman's version and we've had other people's version, but it's these types of specific events that either add up to a cover-up or don't add up to a cover-up, but that's all the things that have been alleged.
The answers the question of what the president knew, when he knew it, and what acts he took that amounted to a favoritism. And today you see one of those acts of favoritism. His friend, his former Commerce Secretary, Maurice Stans, was financial secretary to the committee to re-elect the president and did not have to go before the grand jury and put up with what any other citizen would have had to put up with under those circumstances. And I think Senator Ervin made a very valid point that this was a favoritism, and Senator Howard Baker agreed that it was an unusual, a unique proceedings. He stopped short of being critical of it. But
all right, gentlemen, thank you very much. Peter Kay talked a few minutes ago about the desire of several senators to work right on through August to get this Watergate phase of the hearings over with. Senator Gurney said in one of those mob scene television interviews during the lunch break that for the good of the nation, these hearings must be quickly concluded so the orderly affairs of government can resume. This is the same sentiment that has been offered by others. President Nixon said it in an indirect way the day he got out of the hospital, chastising in effect all of the senators and the ordinary people like you and me, I guess, who are wallowing in Watergate. There seems to be a growing feeling that if these hearings will just finish with all the pertinent witnesses, Ehrlichman and then Haldeman and Colson and then Gray and Kleindienst and Krogh and Helms and others, then suddenly it will all be over, wallowing in Watergate as well as the crisis in government that goes with it. Like magic, we'll know whether or not President Nixon knew about or participated in Watergate and its cover-up, whether or not John Dean or John Mitchell or John Ehrlichman or Jeb Magruder or any of the other witnesses are lying, and so on. Well, this is nonsense, in my opinion. Hearing 15 versions of the same meeting means only that we've heard 15 versions of the same meeting. It does not mean that the minute the bright lights in the hearing room dim, all truth and knowledge will crystallize like a neon light across the sky. Forget it. It just isn't going to happen. There are too many indictments and trials coming, and that crucial tapes issue must be resolved, among other non-hearing things. And besides, Peter Kay, Robert McNeil, and I are due to go on vacation on August the 3rd. And for those three gentlemen and myself, Jim Lara, have a nice weekend. We'll see you again on Monday.
From Washington, you've been watching gavel-to-gavel videotape coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. This coverage is made possible by grants for special events coverage from the Corporation for Public Broadcasting and the Ford Foundation, and has been a production of NPACT, a division of the Greater Washington Educational Telecommunications Association.
Thank you.